Yes.
Lordship, I have filed one application for vacating the interim order, Lordship. The petitioner is holding the interim order, not letting us enter into the premises of the charge, Lordship. It is a matter regarding a charge, and Christmas is near. For that, there is urgency, Lordship. And
Lordship,
Application
may
on
I,
Thursday.
Lordship, may I permit to mention a new motion matter for inclusion
Thursday,
in
Lordship,
list?
Thursday, no adverse will be there, Lordship.
Then it will be taken up on Friday if advocates are not represented.
New
If
motion
parties
matter,
are not represented, yes.
new motion matter for inclusion in the list.
Matter of which year?
2024,
filed?
2024.
2024.
Yes.
Matter relates to?
Unauthorized construction and municipality did not take action.
Tomorrow. Tomorrow service is complete.
No, services complete. Yes, Lordship.
Yes.
My lord.
A motion, my lord, of 2024. My lord, it is, there was a direction on August 2024 upon the state respondents to file a report whether my plot of land has been acquired or not, madam. Subsequently, in this another second in August, it had come up in the list, but thereafter it is not come, my lord.
It is at the motion stage.
It is at the motion state, my lord.
Thursday, my lord.
Matter, Lordship. This is hearing matter, Lordship. Hearing already concluded, and one report was called from Bar Council of India, Lordship.
If hearing is concluded, then you mentioned before the bench. Matter of relates to which year? Matter of which year?
Lordship, but report is pending since September, Lordship, and the petitioner is a law graduate, Lordship, and he's suffering from 1.5 years, Lordship. Kindly inclusion in the list, Lordship. Hearing already concluded.
If hearing is concluded by some other court, then how I can hear this matter?
This court,
There was a direction for affidavits.
Lordship,
Whether affidavits have been exchanged.
only one report was
Called for.
Yes,
Friday.
Lordship.
My lord, may I be permitted to mention, my lord, one hearing matter. My lord, the petitioner's dwelling house has already been acquired. And my lord, the National Highway Authority, my lord, in full swing, my lord, their my lord, construction work is in progress. At any point of time, my lord, the dwelling house will be demolished, my lord. My lord, exchange of affidavit has
Petition of which year?
my lord, 2023. My lord, affidavit exchange has already been completed, my lord. He is, my lord, the NH authority is hounding, my lord. Any point of time, my lord, dwelling house will be demolished.
Monday.
May I be permitted to mention, Milord, a matter?
Not Monday, Friday. Friday.
Milord, may I be permitted to mention a matter, Milord?
I'm seeking for inclusion for extension of interim order that is expiring on 20th.
28.
20.
20. Nineteenth under the heading extension of interim.
Lordship, may I be permitted to mention one matter, Lordship, under heading hearing.
Serve notice upon other side. Extension matter. Extension matter, serve notice upon other side. Again, serve notice, the matter is fixed on,
90.
yes.
Space still, Lordship, is a matter pending, Lordship, since 2021, Lordship, and in the larger bench, Lordship, the way federal law has been given, Lordship, kindly, Lordship, take up the matter, Lordship.
Affidavits have been exchanged. Friday.
Lordship, in this matter, all pleadings are completed, Lordship, and the Honorable Court in its last date has recorded the failure of amicable arrangement. Lordship, the case is due for decision since very long.
When the last order was passed?
13 November 2024.
What was the order passed? Go through it and mention tomorrow.
Lordship, extension of interim order. Lordship, this is a new motion matter. If on the last in the month of an order was passed that to serve upon the respondent, we have completed the service.
What is the matter about?
It's related to GST, your Lordship. 16.4 in the ITC was disclaimed and we were rejected.
Well, let me see. Let me see.
Lordship, may I permitted to mention a matter, Lordship?
There is a direction upon the CGST authority to file report in the form of affidavit. But there no affidavit has been filed by the CGST authority. Direction on 13th of
Monday. Writ petition at the motion stage. Motion stage, when the last order was passed.
13th of my lord September 2024.
Monday, yes.
My lord, may I be permitted to mention, my lord, a matter?
Yes, just a minute. Yes. When you have filed, why it was not there? Monday.
But sir, may I permit to mention that this matter relates to police in action. This is on motion stage and
When the matter was filed,
matter was filed in the
writ petition of which year?
November this year.
So why this matter was not taken up?
I become ill, therefore it adjourned.
It was adjourned.
I'm ill.
So wait for some time.
Lordship, may I permitted to mention a matter for extension of interim order, Lordship?
When expiring?
Lordship, already expired. Subsequently, we have filed the CAN application, that is CAN 4 is pending, Lordship. It expired on 30th.
It was expired,
30th
already expired.
Yes,
Now
30th
you have
November.
filed an application for reimposition of
Yes,
interim
yes.
order.
30th November, Lordship.
Expired.
Yes, Lordship. On 1st December, we have filed CAN application, Lordship.
Thursday.
Grateful, Lordship.
Yes.
May I be permitted? It's a matter related to land.
Yes, Mr. Bhattacharya.
My lord, Mrs. Singh is there, perhaps, my lord. I
Yes,
am,
Lordship.
my lord, upon notice, I am seeking to mention a matter, my lord. If it can come day after tomorrow or Friday, my lord.
Yes, a
It
matter related-
concerns the construction of a multi-speciality hospital in Bagdogra area, my lord, on my own land. Now, my lord, the Air Force Authority is creating a problem saying that it is in close vicinity of the Bagdogra Air Force Station, and therefore they are just, my lord, merely, my lord, not permitting me to raise the construction. That is the subject matter. It's a
it is
multi-speciality
your land.
charitable hospital.
Your land and you are the developer.
No, yes, my lord, I want to develop a multi-speciality charitable hospital. I am Terai Tea Company. I have a tea garden, you know, otherwise, you
Yes,
know,
yes, yes.
now,
But now
see
you
point,
want to, you want
construct
to,
a multi-speciality hospital there. And, you know, all permissions are
it is a
there
writ
from,
petition, hearing
it's a
stage.
writ petition. He, on affidavits, my lord, it's a 2024 writ petition. The previous bench of Justice Sarkar was disinclined because her ladyship has already passed an order by which I am also covered. So, my lord, therefore, the matter has been directed to appear in the next circuit. So, my lord, it was mentioned in the earlier circuit of Justice Basu. Justice Basu directed it to appear. For some reason, it has not appeared. You know, may it appear in any of the 3 days convenient to your lordship. Any
No,
of the 3.
let it be on Monday.
Monday, you know, Monday, you know, I'll be
Out of station.
No, not out of station, but Monday will be little uncertain in the sense, Tuesday I'll be leaving.
So then,
Well, Monday your lordship keeps it. Very well, keeps it on Monday. I shall try to go personally.
oh, you have to come here.
I will go, yes, of course. If it can be accommodated on
Then-
Friday, I'll be extremely grateful. Upon notice, I'm mentioning Mrs. Singh is going to once again serve notice.
Who are the parties?
The parties are, the
Union of
Union of India. Mr. Mojumdar is appearing. The learned ASG there. It is the state and the union, especially the Union of India is the party.
Well, on Friday under the heading hearing.
Very grateful. Grateful. I'm extremely
My
grateful.
lord,
Lordship, this is a motion.
my lord, may I be permitted to mention one matter? My lord, it is
Wait.
On last occasion, the order
I'm
was
grateful to your lordship.
given to the
Leaving.
state of land acquisition collector of Darjeeling to file a report within.
Motion or hearing?
It's,
When you have filed it?
this year, 2024, September, in the month of September.
Why this was not heard?
This was heard on 25th September, the last order was passed, directing the special land acquisition collector Darjeeling to file a report within 18th of November 2024. That has not been done yet. We are on behalf of the.
Thursday.
May I permit
My
to
lord-
Motion.
lordship?
Yes.
New motion,
My
new
lord-
matter, lordship.
When you have filed,
3rd December, lordship.
matter relates to,
Lordship, seeking for lordship transfer of marriage register, lordship. I'm going for consideration, the only consideration, lordship.
when you have filed it? Yes.
3rd December, lordship.
My lord, may I,
Tomorrow.
May I
Lordship,
just-
I
my
have,
lord,
my
may I,
lord,
my lord,
Urgent matter. 8 commodity side. And 23.
What is the urgency?
Relating to importing salt. Just difficulty to issuance the zone. It was
Wait for some time. All matters cannot be accommodated. Yes.
My lord,
Any other
My lord, may I-
mention?
my lord,
my lord, it is
Why you are
extremely
mentioning
urgent, my
again?
lord.
One at a time. Sorry. Yes.
Council, learned Shopan Kumar, Nalin will mention the matter. He is in the video.
my lord, may I permit to the report is submitted by the forensic
You
laboratory.
mentioned yesterday. I have disallowed your mentioning, Mr. Mujumdar.
Because my learned friend was not there.
Sorry.
That's why.
Call the list. Call the. You mentioned
My
yesterday.
lord, my lord,
I remember.
my lord, I have tried mentioning yesterday, my lord. My lord, this is extremely urgent. My lord, my consignment is stuck in Kuch Bihar. My lord, I am an interstate trader. My lord, my coal is supposed to come from Nagaland to
Writ petition
Bengal.
of which year?
My lord, this year, and this is new motion, my lord, this matter was initially filed before the principal bench, but it has been subsequently transferred in this bench, my lord. And
When
this is
it was
extremely urgent,
transferred?
my lord.
When it was transferred?
My lord, it was transferred last week, my lord.
What is the
My
date?
lord, by an order passed by the Honorable Justice Tirthankar Ghosh, this matter was transferred to the circuit bench, my lord.
It's a group
It
9
was-
matter.
Yes, my lord.
Group 9 matter. So
Yes, my lord. It is in new motion, my lord.
who are the parties?
My lord, the parties are police officers, my lord. They have seized my vehicle along with the consignment, and the petitioner is having to pay huge compensation for holding the consignment, my lord. This is he is suffering extreme loss of business, my lord. This is in new
Thursday.
motion.
Thursday.
Deeply obliged, my lord.
No further mentioning, please.
Number one, my lord, I appear on behalf of the court. My lord, the contempt application, my lord, page 105 is your lordship's order. Page 105 onwards.
Yes, what decision has been taken by the respondent number 10?
10/6/2024, my lord. The overflow, my lord, the petitioner was called for a hearing, my lord.
Yes.
Subsequently, my lord, thereafter, my lord, no action was taken from on their
Whether the
part.
petitioner appeared?
Yes, my lord, the petitioner had appeared, my lord.
Thereafter, what happened when petitioner appeared before the
Lord, on 10
respondent number 10?
My lord, if kindly takes up page 15 of my application, I have mentioned in my application, my lord. On 10/6/2024, my lord, he along with his representative Shri Vivash Kumar at 1 PM or at the office premises of the responsible.
Page 15.
Page 15 of my application.
1-5.
1/5.
Paragraph.
Not one. Not the on page 14 it is paragraph 4. It's on page 15 is the operative part, my lord, second paragraph.
When the hearing was conducted,
My lord, on 10/6/2024, my lord, at 1 PM at the office of the DPRDO, my lord. So far as my instructions are concerned, my lord, on 10/6/24, they had assured that they'll pay the amount.
issue. Still, this alleged contemner is there as
So
district
far as my
content and world
instructions is there,
development.
is there. So far as my instructions are concerned.
The learned advocate representing the applicant, the learned advocate representing applicant alleges violation of the order dated 23rd February 2024, passed by this court on the connected writ petition. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon the alleged contemner, enclosing copy of the contempt application and the copy of this order by এটা একটু ঘুরিয়ে দাও তো। One week after Christmas vacation and file affidavit of service on the next date. List the matter on 24th January 2025. When this court will be available in the principal bench. So if there will be an indication in the list, indication in the list that the matter to be taken up on virtual mode. আচ্ছা, আর একটা লাইন অ্যাড করে দাও, আর একটা লাইন অ্যাড করে দাও। Pendency of the contempt proceeding shall not preclude the alleged contemner to comply with the order
My lord, one indulgence.
passed by this court.
My lord, one indulgence, if a line may be added, that the file may be transferred to the principal bench, my lord.
Let the records of this contempt proceeding be transmitted to the principal bench
Yes.
immediately. Yes.
There is no scope available to interim order. I said that what facts, my lord. I have a tea garden. The central government explored the many scheme for subsidy on different components. I applied for it here on sub.
You have a tea garden?
Yes.
Yes.
So central government issued framed the subsidy scheme for financial incentive to the tea board. Here I applied for a subsidy.
To get the benefit of that scheme.
Yes, I applied for, they have issued no objection, I completed.
Who has issued no objection?
Keyboard is the authority. Then
It's a regulatory authority.
Yes, I concluded I completed my function. Then new scheme has come, then those are pending, they're saved. Now new scheme has come, they said those are excluded.
There is total exclusion. To what extent there was an
They
exclusion?
said all the pending cases are excluded.
So your case is this under the previous scheme. Under the previous scheme, you applied for getting incentive.
Incentive on this.
And there was no objection by the tea board.
No objection
Now
is not
that
is not the my lord promissory. No objection they have given, then I won.
Then you,
I executed my one. And they have given a report.
what work you executed?
Here, this relates to replantation. if you also can want application or
Deplantation,
replantation.
replantation.
So pruning, replantation and rejuvenation. These are three.
So replantation work in your tea garden you have done.
Yes. If you can come to take, my lord, 217. Was it?
17.
217.
217.
But this is the inspection report. They say I executed the work by the field officer.
Yes, 217 and except P4.
I
Yes.
got this is a fast inspection report. Sorry, fast inspection report. Their officer said I executed the work. Can you see next page?
Just a minute. Yes, page 27, 217, what you want to rely upon.
I show that they have given no objection. I applied the
Where is the no objection?
No,
whoever
sir,
this
yes,
is
it's a
said,
fast inspection report. They
The T board.
they
set of
conducted the
routes,
report
regulations,
and found that I did the work.
Operations.
Last night, the work has been carried out that in terms of approved the keyboard related the scheme. Last line I can see. Attached to only 18.
It's page 27 to 217 is merely a report on inspection.
Inspection report.
Yes.
18 to 18 can come.
Then 218. Yes.
Last time, the work has been carried out satisfactorily in terms of the approval as contained in keyboard letter, the scheme. Next one can come to page 219. This is a final inspection report. So, my lord.
Yes, inspection report then.
People can come to page of the scheme. Page
But there is no objection as I haven't found any no objection.
no.
It's a mere inspection report.
I applied for, they have asked me to work, execute work, this report. Now you can come to the scheme itself at 196. Part of this relevant part of the scheme. Can you see? Upon this is the first inspection report, upon this.
Page 196, where from you're reading?
Upon receipt of the first inspection report. This is
Yes.
Last line, upon receipt the letter of undertaking from again, first inspection of service to be disbursed. When this is the system. Next, my lord.
Special purpose T fund scheme of T board. Special purpose. So this is the scheme.
Scheme.
Special purpose T fund.
Yes, you are absolutely correct. This is scheme. So I have to execute the work.
Special purpose.
But central.
First installment of subsidy is lost. Yes, scheme says that upon receipt of letter of undertaking from applicants, first installment subsidy is to be
After the inspection report too. So this is my completed. What happened by this time, the scheme has been expired. Now that you also can come to the scope, I have to page 235, the new scheme.
Where is the 235?
It's come, can you 235? And just
Yes, 235.
235 is a new scheme.
Where the, from which page new scheme starts?
The NKF scheme of 230. 230. NKF scheme. Yeah, can you come to page 235?
Just a minute. The previous scheme under which you have applied, from which page that scheme starts?
Page 194.
194. Special purpose T fund scheme of T board. Now,
This is scheme,
it appears from that new scheme, the development and promotion scheme for medium term framework.
Yes.
That started from 29 December
Yes.
2017
Yes.
up to 31st March 2020.
This is called MTF scheme.
So that this scheme has also ended.
Yeah, I know. This is
Let's say in page-
just please, sir, I'm answering.
Yes.
The MTF scheme, yes, you are also correct. Now can you come to page 235?
So today, how you would get the benefit of the scheme which you are relying upon is coming. So not yet mooted.
No, ours, can you see?
Yes.
Page 235. 235 of the MTF scheme. Those cases of pending claims are
Where page 235?
to be objectives minor and last 4 lines.
Activities and subcomponents, page 235, there is a heading. Then which part of page 235 you are relying upon?
Objectives,
Objectives, yes.
last 3 lines.
Yes.
Pending claims for application submitted on the scheme.
Submitted.
In this small thing was would be accommodated during the meeting.
The objective of this component
Yes,
is
yes.
to increase production and field productivity and quality of tea by encouraging replantation, replacement planting, then rejuvenation, pruning, irrigation.
The last 4 lines.
Last 4 lines.
Pending claims,
Just a minute.
pending claims for applications submitted under the scheme, including.
Page
small-
235, there is a heading objective. Then 1, 2, 3, 4 pending claims of for applications.
Submitted, the 11, 12 plan activities, if a small thing was would be accommodated during the midterm scheme and will be. governed by
During the medium term framework.
Scheme.
Yes.
So this
And
was
will be governed by the guidelines that were framed
the spirit scheme.
under the respective
Earlier
schemes.
schemes.
So
when you see-
pending claims for applications
Yes.
submitted under 11 and 12.
Yes.
Just a minute. Plan activities including small
So those are-
tea
those are
growers
safe
will
ones.
be accommodated during the medium term framework 2017-2020. Just a minute. 2020 and will be governed by the guidelines that
The respective-
framed under the respective schemes. Yes.
No, I say what I answered.
No, the problem is this.
I
Your
answered.
yeah, problem is
But
this,
you are saying those are
that-
scheme is over, then
yes,
I just answering.
on relying upon the objectives at page 235 in connection with the scheme
MTF
of
scheme.
that is medium term framework.
What is that? What is that?
The previous applications which were made
Pending are-
based on the scheme, previous scheme were saved. But the point is, this scheme has also expired on 31st
Now
March
I'm coming.
2020.
I just answering your lordship.
Yes.
Queries, you said that scheme, this input states, I this happened, I place on a matter, so I apply for the scheme, one scheme. And my application is completed successfully. New scheme has come, that will not take my rights. This is federal law. I'm not going to that.
No, what is the
Now-
position? What is the
now-
position after 31st March
Now
2020?
present position is just coming.
No, not present position. You have to show the continuity of the process. So after
They are-
31st
they are
March
not given.
2020,
They
what was
said-
the situation on and from 1st April 2020?
There, what happened? Now the new scheme has come. Can you come to this 330? T36. It starts from T36. Got it, madam?
Just a minute. Yes.
MTF goes, new scheme has come. Now, my God, how I agreed and come with 368.
Just a minute. Just a minute. Just a minute. Yes, please come to paragraph 1.15 of the Tea Development and Promotion Scheme for the period 2021-2026. Yes. Yes.
Yes, this is my.
Don't take me to the history. Come to the relevant.
368.
Yes.
368.
The issue which is required to be considered in connection with the present writ petition.
368.
Three
368. They excluded all. Earlier pending claims.
This where is the first page of this plan?
Yes.
This scheme?
Page 336.
So that has not been continued. So for replantation, replanting is considered.
I agreed with this because of my lord. When I applied for the scheme, they have allowed me to exit the work.
You have applied under which scheme?
This is part of 12 plan scheme.
You have applied initially, and as you have submitted, Mr. Rai,
Special
you have applied under the scheme.
scheme, this is at
Uh,
194.
Yes,
This
under
is
the scheme,
Madam,
and what was the duration of the scheme?
the scheme was started from 2007 onward. That was 2007 onward. It's a part of the 11 plan scheme. At page 191.
So if your scheme, your application was not processed under the scheme,
New scheme.
not under the scheme of the development, that is called the development and promotion scheme for medium term framework from 29 December 2017 to 31st March 2020.
I just hang on.
And since the present scheme is mooted, is Finance Commission 2021, that is from 2021 to 2026.
Yeah.
So, and if your scheme was not processed during the first scheme and the second and in second scheme, if your scheme was not saved, then how at present you can get the benefit of the scheme? Because the even if it is saved, but that scheme is after discarding that scheme. Now present scheme is under operation. You show me that under the present scheme, you have a right to get the benefit of incentive.
No, I agree with you. I just say whatever. There's the first 11 plan scheme. This is special scheme, then 11 plan scheme, then 12 plan scheme, then MTR now new. But I apply under the 11 plan scheme of part of that.
First, you have applied chronologically, if I consider, just a minute. Special purpose T-fund scheme of the T-board workflow. That is the scheme. What was the duration of this scheme?
It started from 2007.
Where from you are getting? January 2007, yes.
Scheme was introduced during the January 2007.
And how long it lasted?
No, it was then merged with the 11 plan scheme. 11 plan scheme. But these are not disputing. So I executed my work. This is the pendency of my scheme. Now 12 plan scheme.
No, it's not an execution of your work. It was on the basis of the inspection. And a report was prepared.
No.
And in the report, under this inspection was as you have relied upon.
Yes,
this inspection was made in connection with which scheme?
So part of the plan scheme, 2017.
228 is the inspection report.
Second report. 17 first. 2017.
Date
first.
of commencement, then date of completion, date of
18 September 17. It is going on. Can see.
18 June 2020, date of inspection.
17.
Page 228.
2017 can come.
Date of inspection at the top right hand side, 18 June 2020.
You know, this is the second, first of 2017. Sorry, my God.
18 June 2020, please come to page 228.
Yes. Sorry, my God. Yes. Yes, this is the first inspection report.
18 June 2020, this is the first inspection report. This report was in connection with which scheme?
Special part, can you see the page 117? First, they are given.
Whether this inspection was made in terms of the scheme, which starts from page 194 from January 2007.
2007, you can see the special purpose people scheme.
Yes.
They have said it started introduced in 2007. But I executed my work, they made the inspection on 2017 in respect of special purpose people scheme.
That is an 18 June inspection,
Yes,
2020.
Yes.
Now, please satisfy me that in terms of the special purpose T-fund scheme of T-board, now that scheme was prevalent at the time of inspection.
But this is not the issue. This is not the issue because it's a replantation. it takes time. They cannot impose any bar.
No, but in the meantime,
My
a
lord.
new scheme was
11
formulated, was introduced from 29 December 2017.
11, before that, there's 11.
So
schemes.
your case is that on the inspection which was made on 18 June 2020,
my-
that was in consonance with the scheme mooted in
that-
January
That's
2017.
done by then. not
January
by me.
2017,
Yes.
but by that time, new scheme was
Yes, no,
introduced
no,
from
no,
19
no,
December
no.
2017.
This scheme has come. But
20
after-
December
but I just-
2017, at that scheme,
You say
second scheme, please apply your mind. Second scheme lasted from 19 December 2017 to 31st March 2020.
Before the other scheme.
Yes, thereafter, at present, the scheme which you are relying upon is the procedure for implementation of tea development and promotion scheme.
Yes.
That is Finance Commission 2021 to 2026.
I-
Now, how
Answer
the previous inspection which was made in 2020 in connection with the scheme which was mooted in 2017 to 2007 can be taken care of on the anvil of the present scheme.
Yes, but I'm coming. So, but. Can we-
A far-fetched issue.
Lordship.
Yes.
So I ask for the affidavits.
Lordship, can I-
No, affidavit is not a matter of right, Mr. Rai. Yes.
Satisfy your lordship.
Yes.
But then your lordship, can you hear this matter? Can you fix it tomorrow?
Yeah, I'm hearing this matter. For last half an hour, what I am doing?
I'll say this.
Yes, please place your case and satisfy the query of this court.
Then
Yes, I am allowing you.
So, my lord, I apply, just a minute, I apply under the special purpose refund scheme.
So why you are not applying under the procedure for implementation of tea development and promotion scheme afresh?
Why do? This is pending. Can you see? I just
Please demonstrate that this is pending.
You also can you allow me? Just.
Yes.
But so you also have seen the inspection reports shown. You also kindly come for a moment. There's 196 for a moment. Oh, sorry, kindly come to 196. 196. The scheme says that after inspection, I'm entitled to get the disbursement of the benefits. Can you please 196 or a moment?
That was in terms of 2007 scheme.
So, yes.
That was not alive
Yes.
after the scheme which was mooted from 2017. From 2017. Now you have relied upon page 235 in order to show that there is a specific provisions under objectives clause capital English capital A, where it is stated pending claims for applications submitted under the Roman 11 and Roman 2 plan activities, including small tea growers, will be accommodated during the medium term framework 2017-2020. Yes, 2017-2020, and will be governed by the guidelines that were framed under the respective schemes. Now, if that provision is absent in the present scheme, which is there in the present scheme, if that provision is absent, your previous exercise goes.
Can you see? This Supreme Court says, I just place the judgment, Your Lordship, that I know the Supreme Court says, when I made the application, if it is within the time period I made, and that has been acted upon. So even the scheme goes, my right will not go. This is a settled law.
So what is
my point
how you are prevented to make an application under the present scheme?
How you execute the wow? You also can't see. Once I'm sorry, my lord. What happened, my lord? Yours is absolutely 2007 scheme. I executed the one. Then towards the 11 scheme has come. Then 12 scheme has our pending cases are pending because of financial.
Yes, because I am not considering 2000. I am not asking any questions with regard to 2012-2013 scheme, because this is a scheme from January 2007. Now inspection was made according to you on 18 June 2020 under 2007 scheme at page 194. Now, according to you, Mr. Rai, this scheme, this inspection and the activities or exercise which was made by the authority in terms of January 2007 scheme was saved by virtue of the provisions at page 235. Now, if that saving clause is not there in the present scheme which started from 2021, where is your right?
My lord, my answer to that.
Where is your right?
This is Supreme Court says, sorry, This report says, I place the judgment, my lord, I'm sorry, my lord.
If you can address me on the point that the saving clause is still alive from 20, in connection with procedure for implementation of tea development and promotion scheme, then I can direct the authority to continue with to take steps based on the previous application made and inspection was made. But since that scheme, that provision is not there in the present scheme, where is the right so far you were concerned?
Yes, I see that what in my own way, what I'm saying. So MTF scheme said these pending claims are survived. Then now you also in the new scheme, you have been, your claims are discarded. So you're no right.
Yes.
My lord, my first point is that here they have no, they said if there's no sanction letter, no installment paid, those are excluded. Because here my inspection was done, but sanction letter was not given, no installment is given. So there's the pending cases, there's two parts. One, we have been discriminated since we did not get the sanction letter, but inspection report is in my favor. Subsidy has not been paid to somebody else.
I am not disputing, this court is not disputing that there were certain exercise carried out by the authority based on your application as it emanates from from this inspection report, page 228. Now, if but there is no saving clause with regard to the pending application with effect from 2021, where is your right?
This is my challenge.
So therefore apply under the present scheme.
Then my execution of what that will go. But when the MTS scheme pending cases are kept under MTS scheme, the new scheme they have come, but they have not said that they have rejected or kept. They have communicated.
So let there be a direction by the authority, decision by the authority. That since an exercise has been carried out, whether that issue can be gone in 2 years, Mr. Majumdar.
No, my lord. 158. That's the final, my lordship.
I show one judgment, my lord.
Just a minute, please. I have heard you for such a long time.
There is no as such enforceable right on the side of the petition.
No, what Mr. Rice have trying to impress upon this court is this, that in terms of the previous scheme of 2007, there was because if chronology of facts go to show that there was a scheme from January 2007. Now, in terms of this scheme, application was made, inspection report is there at page 228. Come to page 228. Now, page 228, this inspection was carried out on 18 June 2020. 18 June 2020 is an activities relating to replantation. Now, based on the provisions as contained in the scheme, for the purpose of getting incentive benefits, this replantation activities was carried out by the petitioner, and then on 18 June 2020, inspection says that there are certain activities. Now, ultimately, the new scheme was introduced in with effect from 29 December, not with effect, just a minute, from 2021. This court has made a posed a specific query that yes, in the present scheme there is no saving clause so far the previous applications are concerned. But based on the application made in terms of 2007 scheme, when an inspection was carried out on 18 June 2020, and there was an inspection report, doesn't say any adverse adversity so far petitioner is concerned, then upon discarding this incentive scheme or not incentive scheme, upon discarding these applications in view of absence of saving clause, then the entire exercise which was done by the petitioner based on the scheme of 2007 goes.
It appears.
Goes.
So, my lord, if I am permitted, my lord, I'm trying to assist your lordship. Lordship, please consider a scheme will come for a limited period of time, for a limited purpose, for a limited number of people, and with a limited financial packet. So
you are representing T-board.
T-board, Union T-board responsible. But now a scheme is floated, my lord. I need not say this to your lordship. Lordship knows it very well. A scheme is floated. There are certain terms and conditions that I have to meet to get
or avail the benefits under the scheme. Just like availing a loan, my lord, from the bank, that I have to perform certain things, the bank will perform certain things. And if the bank finds something shortcoming on my behalf.
No, that's why, yes, that's why since there is no saving clause, and in
Lord,
terms of this scheme, present scheme which started from 2021.
Gotcha.
Now, if the concerned authority can consider that whether the present
Well,
application can be taken care of or not, let there be an order.
As there is no saving clause, there is no rejection clause that since you have applied on the other scheme, you cannot come under.
So let it be decided formally.
He has not
So
applied.
why court will embark upon the issue at present instead while there is no formal decision by the authority
No,
with
but-
regard to the
Yes,
scheme.
but he should have opted for the new scheme. Because
So that he will do ultimately if he ultimately suffers an order from the appropriate authority.
that can be challenged.
Yes, that he will do.
That can be challenged.
So who is the appropriate authority?
ফর্মাল স্যাংশন অর্ডার লাগবে ওটা না হলে এটা
বলছে ফ্রেশ করে অ্যাপ্লাই করুন।
ফ্রেশ করে অ্যাপ্লাই
No, not first, no
Well,
fresh
well,
application.
My lord,
I have said,
my lord,
this
we
court
can-
has said that let there be an exercise in order to find out whether
Lordship.
the application made by the petitioner and activities done by the petitioner relating to replantation can be taken care of on the anvil of the present scheme or not. If it can be done, then application
Lordship,
can be
in
saved.
that case, my lord,
Otherwise, if it is not done, then let there be a decision by the authority based on which petitioner
Absolutely.
shall take
My
steps
lord,
accordingly.
only one submission that I would like to make, my lord. If Mr. Rai is agreeable to that. My lord, give me 1 or 2 days time, I will call the officer on the keyboard. I will get him.
It's
in-
not
No,
required.
my lord, I will get the instructions. What they-
Let them decide. Tell me which officer will decide.
No, my lord, let me get one instruction.
My lord, sorry, Lordship, I also prefer, I saw that.
No.
My lord, this is 45 my case. I just follow that.
First, let me.
My lord, before your lordship, my lord, may I,
Shall I direct the chairman?
my lord, just.
Mr. Mujumdar,
My lord, kindly takes 2.
today I am not deciding the
No, my lord,
interest
I
right of the
understand.
parties.
My lord, I understand.
Shall I direct the chairman?
My lord, just for 1 second, my lord takes 250.
215 ওটা পেজ হবে
220.
1.15 236
368.
2368
368.
ওই ব্রিফে 268 সেম প্ল্যান এই থার্ড লাইন
My lord, 1.15, may I read it out?
Which page?
কত বললেন মহোদয়?
368. There's that exclusion clause. Right?
368.
1.15.
And
368
Yes, 1.15, right.
Certain activities for.
Just a minute. Which page? 3?
60.
অনেকগুলো ফ্যাক্টর আছে সেটা না হলে ইন্সপেকশন করলেই হবে না তারপরে ফর্মাল হ্যাঁ
360 is 1.18. Where is 1.15?
That is not.
1.18.
না 1.1
1 point, yes, that is indicated. You have just now shown, Mr. Rai. Where is that?
368, my lord.
368. Yes, page 368. Yes, page 368.
Certain activities for big growers and small growers which were approved under the earlier scheme has been discontinued and not included as eligible activities under the instant scheme. However, for these activities, while no fresh applications will be entertained, financial assistance would be considered under the instant scheme only for those cases for which a formal sanction order has been issued and either one or no installment has been released. So here we get stuck.
That has been, the attention of this court has been drawn to this. This particular clause creates problem. Now, if this certain activities have already been carried out by the petitioner in terms of the old scheme, now which is curtailed or which has not been recognized by virtue of 1.15. Now, let there be a fresh decision on the anvil of this scheme.
Allow me to use affidavits, then decide. Because I cannot.
Why court will decide at the first instance?
Sir, my case is. One matter is complete. If you can hear this matter, one matter is everything complete.
All other matters, because all other matters
I started
have
argument.
I think
Justice
Mr.
Singha, I conclude my argument,
No, no.
but he was not complete his argument. So
अरे
you are
बोले
finding one-
आगे
one
तो
matter,
affidavit
just
आता है.
it is a-
In all
आगे
similar
judgment-
matters, I think Mr. I will agree,
judgment
there is a direction from the honorable bench to file it.
Yes,
আর একটা judgment ও আছে।
One matter is evidence is complete. Please hear this one matter, my lord. The evidence is complete. Yes, sir, my junior, he should be lost. He said, no, I will not take the hearing matter. Just only one matter, both.
So I am not hearing that matter. I am hearing the matter which is before me.
No, that is-
Now I want to hear from Mr. Mojumdar, where is the difficulty so far the chairman of the T-board to take decision on.
They use my,
Instead of sending this matter with affidavits
No, my lord, because.
to remain
My
pending
lord,
for
please
some time.
appreciate, Mr. Rai will also say. I-
Why you are feeling shy?
No, no, my lord, I'm not.
In
feeling shy
taking
because,
decision.
My lord, these matters are similar.
this is good for me.
Yes,
If
I know,
in
my
this matter, your lordship directs the chairman
Yes,
to take a
yes.
decision, all the matters will come in line.
yes.
But in certain.
If that decision ultimately, if that decision may touch upon the issues which are pending before this court.
Similar matter.
And on the next circuit, the coordinate bench may pass an order similar in those matters.
That will help me either.
That will obviously help him, not me.
No, help.
No, why? You will, I am not directing the chairman of the T-board to extend the benefit which
No, no,
was prevailing from,
I fully understand what your lordship.
he has to apply his mind and take a decision.
My lord.
That why at
No, no, my lord,
present,
in 10 out of 10 cases, in 6, the chairman has filed his affidavit.
maybe, I am not impressed on this. I have heard this matter for last 45 minutes. So I find that since there is no prima facie preliminary decision by the authority concerned with regard to getting the benefit of incentive on the anvil of the present scheme, let it be decided first by the chairman of the T-board.
My lord, just allow me to come back tomorrow, I will get the instruction from the chairman.
আমরা ডিসিশন আছে তো একটা।
2-6.
1 to 6, my lord.
2 to 6.
What I said,
2 to
2-6,
6.
2-6, the same. I know, my lord. You know, I said that my lord will not allow. They were between. So I had myself.
Issue.
ফর্মাল স্যাংশন অর্ডার তো নাই না এটাতে এটা
No, no.
Yeah, that is.
Keyboard.
Sorry, I didn't do that.
I would not have hesitated to enter to consider deep into the matter if there would have been a formal decision. Let it be decided by the authority that since there are past activities in terms of the previous scheme, and you are absolutely correct. You have drawn attention of this court so far. Clause 1.15 is concerned. There is a bar. So considering the ground reality, let a decision be taken at least by the authority prior to considering the issue finally on exchange of
You
affidavits.
know, they appreciate the concrete of the decision.
Mr. Mojumdar, please
Lordship-
use your good office.
Lordship,
Since you are there.
I always try to use my good
Yes,
office,
that I know.
but
That I
sometimes
know.
it becomes bad.
That I know.
My lords have the article experience. My lords knows it.
I know my lord also.
2-6, tomorrow.
Matter is heard at
But
length.
lordship,
Matter is heard at length in presence of Mr. Amoresh Rai, learned senior advocate representing the petitioner,
Delhi.
representing the petitioners, and Mr. Mojumdar, learned additional solicitor general, deputy solicitor general, learned deputy solicitor general, Mr. Mojumdar, learned deputy solicitor general. Stop. Next paragraph. Learned DSG has prayed for 1 day's accommodation to obtain instruction. Stop. List the matter under the same heading tomorrow for further consideration.
But my lord, one thing I should draw your
Yes,
lordship
please.
attention. My lord shouldn't have heard Mr. Roy. Mr. Roy, after being designated as senior, till they had not invited us to any, and even a cup of tea. This is a very serious
My
thing.
lord knows that I'm not, time of myself. I'll do 6, I did.
Mr. Mojumdar, I have a bad habit of not passing an order of order for exchanging affidavits without applying mine.
No, my lord, this is not the first. I have also followed your lordship. This is, I think your lordship's fourth visit.
Your lordship here, I did many matters, and don't be your lordship.
Yes.
So lordship trying to make it.
No, obviously, my lord, if there is no, until there is a concrete
Because
dispute.
Mr. I am telling both of you, both are the senior advocates, that this is circuit bench.
Lordship,
There is a difficulty in hearing all the matters.
absolutely, my lord.
Hearing matters are pending. If at the threshold matter can be disposed. of,
Yes, my lord.
And if at the executive level, it matter can be decided
Absolutely.
based on the guidelines which are being passed, based on the orders which are passed by the writ court. I think many matters, many issues. can be
Absolutely, my
sorted.
lord. There are matters which can be that way disposed of.
So instead of, especially while sitting in circuit bench, especially instead of passing an order for directions, I always try to find out ways and means whether the issue can be.
But my lord, from March, we hope that the things will change.
But 1 to 6, 2 to 6 are identical.
Yes, same order,
Yes, my lord.
same order.
My lord, item number 7, my lord, I am for the petitioner. My lord, item number 7, I am for the
Yes.
petitioner.
Yes.
My lord, I am for the commission. My lord, I am for secondary education in Lakshmi. My lord, this is the matter of re-recommendation.
Who is for the respondent? You are for the respondent. You are for
I am
the.
applying to respect. I am for the board, your lordship.
Where is the affidavit of service?
I am for secondary board, your lordship. My lord, my junior Mr. Somojit Raha is there. Somojit Laskar is there.
The school has been served, doesn't appear so.
Epidemic service, school service হয়েছে?
Mathavanga Girls High School. Now, we have served upon the learned and government leader, state is represented. Now, item delivered to Shech Bhavan, Resident Authority, then Devgram Biobit, that is the school. Not delivered, don't lock. Yes, what is the matter about?
Last Saturday. My lord, re-recommendation. My lord. My lord, the petitioner before your lordship is a clerk, Group C clerk. My lord, my lord, petitioner applied for the transfer in Utshosri portal, and my lord, page 15, my lord, kindly turn page 15 on 3rd January 2022. Petitioner has been recommended for transfer from Mathavanga Girls High School to Ramthanga High School, Kuch Bihar.
Yes.
My lord, page 15. My lord, corresponding transfer order, my lord, correspondence transfer order has been issued by the board, that is in page 17, 8 March 2022. Page 17, corresponding transfer order by the board.
Yes.
My lord, then my lord, what happened on 7th? My lord, next page, very next page, page 18. My lord, petitioner went to the school where the petitioner has been transferred, that Ramthanga High School, page 18. My lord, on 7th March 2022, that school has issued a notice that there is no vacancy in the school. Page 18, my lord, kindly see. My lord, first two lines, the undersigned would like to state that the vacancy to the post clerk is Ramthanga High Schools has already been filled up as per appointment letter issued by favor of the Omlan Roy White so and so memo dated 3rd March 2022. Page 18, minute necessary communication from the school where the petitioner has been transferred.
So this is your page 19 is the application for re-recommendation.
Re-recommendation is pending before the commission.
So let it be decided by the commission.
Yes, my lord.
Yes, commission, do you have any
Yes.
objection?
No, my lord, no, my
The
lord.
school is not required to be heard.
No, yes, my lord.
Since the petitioner could not join the post
Post, my lord.
in view of the fact that the post was filled up, let it be decided by the commission afresh.
Yes, my
My
lord.
lord, subject to correction on Saturday, my lord, school has been delivered. It is my instruction. Saturday, the school has been delivered, the summons has been delivered. Notice has been delivered
No,
upon the school on
not
last
delivered.
Saturday.
Yeah, very well, you need not dilate on this issue. The
Lordship,
petitioner is a
Lordship,
clerk.
Lord.
Petitioner is a
Group
clerk.
C clerk, below. Yes, my lord, clerk.
Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner, clerk of Mathabhanga Girls High School, Kuchbihar. District দেবে না তো? Mathabhanga Girls High School, Kuchbihar was recommended for transfer to Ramthanga High School, Kuchbihar, with a recommendation memo dated 3rd March 2022, issued by the Secretary, West Bengal Central School Service Commission, based on which President West Bengal Board of Secondary Education issued appointment letter dated 8 March 2022. 3rd March and then 8 March. Stop.
8 March.
Learned advocate representing the petitioner, placing reliance on letter dated 7th March 2022, issued by Ramthanga High School, Kuchbihar, has submitted that petitioner was informed that the post where he was transferred was not lying vacant, which was not lying vacant as a result whereof appointment letter টা না transfer order করে দাও তো appointment order to transfer order. As a result whereof transfer order dated 8 March 2022 issued by the board could not be given effect to. Stop. Petitioner made application on portal or on Utsotsi portal seeking re-recommendation. Next paragraph. State respondents, West Bengal Board of Secondary Education and West Bengal Central School Service Commission are represented by learned advocates. Stop. It has been submitted on behalf of the commission that if concerned authority of the commission is directed, an exercise can be carried out for re-recommending the petitioner subject to availability of vacancy. Next paragraph. Having considered the submissions made on behalf of the parties, writ petition stands disposed of, directing the chairman, West Bengal Central School Service Commission, being respondent number 3, to call the petitioner by 4 weeks from the date of communication of this order and disclose the available vacancies for her transfer. Stop. If petitioner opts for a vacancy which would be disclosed to her, an appropriate order shall be passed to re-recommend the petitioner based on option to be exercised by the petitioner. Let's stop. Such order shall be passed. Stop. A formal order shall be passed on completion of aforesaid exercise by the exponent number 3 by 2 weeks thereafter, and same shall be communicated to the petitioner by 1 week thereafter.
Great.
Perhaps it made clear that submission of portal shall not be a ground to reject the application of the petitioner seeking re-recommendation. Urgent xerox certificate copy.
Online maybe at a DI.
I'm extremely grateful.
DI secondary Kujwar is also represented.
Yes, I have stated the state respondents are represented, my lord.
My lord, item number 8, I am for the petitioner. My lord, this is the matter of, my lord, this is the matter. My lord, this is the matter of, my lord, primary school, my primary teacher transfer.
Yes.
Petitioner before you lordship is a primary assistant primary school teacher. My lord, what happened? The service length of the petitioner is below 5 years. Now,
Below
rule,
5
my
years.
lord, rule provided
Below 5
below
years.
5 years.
Yes.
Yes, below 5 years. But that rule provides that I have annexed before your lordship that, my lord, the page number, my lord,
35.
page number 11, page number 38, which stated, my lord, rule 5 has been substituted, substituted on amendment 3rd September 2021 to 2002 rule. My lord, since it is almost similar to secondary transfer, rule 5, sub rule 3A stated, my lord, kindly see, my lord, page 38.
Sub rule 3.
Yes, my lord. Rule 5, sub rule 3A, page 38 of my read application.
It's an amendment.
It has amendment. 3rd September 2021, it has been amended 2002 rule. Serious problem attending the school. My lord,
Just
this
a minute. Rule
3-4 rule.
Rule 5 under rule 5 3A. Yes.
3A.
Yes, 3A.
Well, it has stated that any applicant, his or son daughter suffering from malignant disease, severe heart disease, renal failure, thalassemia,
3A, which
replacement
clause?
organ, serious
3A. It says people
A.
teacher ratio.
So 3 capital.
No, my lord.
3 capital.
38.
Above
3
that,
capital.
above that. What Milord is looking at? Above that.
Above that.
Above that.
Yes,
Above 3.
3 small a.
Rule small a.
3. There is a provision that 3 capital A. Above that 3A.
Yes, 3A.
3A. 3A. Satu.
Just a minute.
May I read out?
That is under amended rule.
It starts with any applicant or his her son.
Any
or
applicant.
spouse.
Yes. Sub rule 3 substitutes following.
Yes.
Yes.
Following. Yes.
Yes,
But any applicant, my lord, thalassemia, gynecological disorder is there, my lord. Just like secondary rule, gynecological disorder is there. I am suffering gynecological disorder. But in these are A to D are the preferred rules, the special ground, and no precondition embargo will attract.
Just a minute.
But lordship.
কিন্তু 6 এর ওই ক্লজটা তো অ্যামেন্ড হয়নি।
Yes,
That's
3
sad.
according to you, according to the petitioner, rule 3A applies in your case.
Yes, and 3A to D are the special ground. No precondition embargo will attract. It has been stated.
But it has been stated.
It has been well stated.
It has been stated that subject to condition made in sub rule 3 capital A.
Subject to
the conditions made in sub rule 3 capital A.
But at which
Yes, rule 3 just above A,
yes.
small a, an applicant
Condition made in sub rule A in following order preferred. Yes.
Please read it. An application
Yes. An applicant may seek transfer on following ground, and same shall be considered by the council only against the vacancy available at the time of consideration, subject to the condition made in sub rule Sub rule
3A.
3A.
Yes.
3A. Now, sub rule 3A, while considering the transfer application made under sub rule 3.
Now, my lord, another aspect is that condition that
Now,
no
where the transfer application of the petitioner is stuck.
No, my lord, just before that, my lord,
Board.
Rule 6, which prohibits, my lord, consideration of any application before completion of 5 years of service.
Just a minute.
That still stands. That has not been amended.
Where is rule 6?
Yes, my lord, it is annexed, my lord, page 35. This is the original rules.
Page 35.
35. Rule 6, bar to transfer. Clause 1, no teacher shall be eligible to apply for transfer for a period to 5 years from the date of transfer.
But whether that is applicable in case of transfer on special ground?
Because, my lord,
No.
if my lord
If it is a transfer on the ground of distance,
Lord,
that
if-
is applicable.
Distance.
Just a minute, just a minute.
If my lord considers the amendment, that 6(1) has not been amended. It still stands.
No teacher shall
Whereas
be
2 and 3 has been amended.
transfer for a period of 5 years. Without transfer. No teacher shall be able to apply. See, the situation come to page 35.
Yes, my lord.
Now, there is a bar to transfer, you are relying upon rule 6.
Yes.
Then 3, rule 6, sub rule 3.
3.
No, sub rule 2. No
Sub-
teacher shall be eligible for transfer if he attains the age of 57
57
years.
years.
Now, in sharp contrast to this, come to page 38.
Yes.
Amended rule 3,
Yes.
sub rule D.
Yes.
Teacher of age of 57 years and more and willing for home district posting.
Right. So,
So
that has
therefore,
been diluted.
therefore the transfer as contemplated under substituted rule, amended rule 3 as in page 38 is not governed by the original rule 6.
Right. But rule 6, my lord, clause 2 and 3 has been amended, but not clause 1.
No, but if sub rule 3 where D is applicable, then that is contrary to rule 6 sub rule 2.
My lord, if subject to lordship's approval, my lord, let the board, my lord, take a decision in light of the amendments.
Yes.
So where your application
Yes, my lord, I have.
why your
My lord, I have my
Answer.
yes, my lord, page 20 is my application, and my lord, coordinate bench judgment I have also annexed similar type of judgment.
Offline application.
My lord, page 20. My lord,
Offline.
offline application. Why below I am stating why offline application page 28. Kindly see the judgment of Justice Mantha. It has been stated, my lord, in paragraph henceforth all transfer application is governed by the offline and the authority has accepted the same. Page 28, my lord. This order remain in force. Page 28.
So at present you are allowing offline application.
Yes, but if directed
Yes,
passed by the honorable court.
Yes. Page 28 is the, my lord, Justice Tamanna Begum. My lord, fortunately, I have moved that application.
It is relying on para 3, page 28.
Correct.
Although it speaks about pending orders, pending applications in the Utshasri portal.
Just a minute, just a minute. I am just going through her application. Now, which order you are relying upon of the coordinate bench?
My lord, I am a coordinate bench order is there.
Page 28, paragraph 3.
Two order I am relying. Page 28, Tamanna Begum, paragraph number 3.
Just a minute.
It has passed on 8th of my lord.
But in this case, applicant made an application on Utsosi portal.
It was pending application.
And it
Yes,
was
yes.
pending application.
It is true.
But it is not
Yes.
a fair that the application made application for
Yes,
transfer was made on portal.
Yes.
So if I
Yes, my
start
lord,
giving
thereafter.
direction, a floodgate will open. You know my
No,
view.
my lord, thereafter authorities, my lord, I
And
am
your
relaying another data. Authorities,
application shows it is not solely on the ground on medical ground. Main ground is
only, my lord,
that your husband is working at a
paragraph
place
2.
which is far away from the place of
No.
work so far petitioner is
My
concerned.
lord, subject to correction, paragraph number 2, paragraph number 2 of my application. This is a medical ground. I am suffering by gynecological disease.
This application you were waiting on by making this application from 12 September 2023 application. So you are waiting for more than 1 year. So wait for some time. If the embargo is lifted after 31st of December 2024, who knows that again there will be a window. So
My lord, phrase application. No, my lord, phrase application. My lord, phrase application, page 26. Phrase application has given on in the November also, in the month of November 2024.
Very well, but the first application on the same line on 12 September 2023.
Yes, it is. It is, but my lord, another application is, my lord, offline mode, and my lord, page 31, it is a medical issue. My lord, kindly consider, my lord, kindly consider that authority, my lord, medical ground is involved. Authority should take a decision, my lord. I am also relying page 31, judgment of the coordinate bench,
The
page
board
31.
is to take decision.
Inter-council.
Inter-district transfer.
Yes.
So who is appearing for the board?
Well, I am for the board.
You are for the board. District West Bengal Board of Primary Education. So who takes decision? Chairman or the chairman of the board? Whether chairman is met.
My lord, president, there is no chairman in the board. My lord, president or secretary. There is no designation in the chairman.
The president of the board.
President or secretary. My lord, secretary is the competent authority. Now all the applications. Yes.
The board is a
all decision is now taking secretary. All decision is now taking secretary.
No, where is the secretary? Whether secretary is a partner.
Yes, true.
Matter relates to affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Matter relates to transfer of the petitioner based on an offline application made on 12 September 2023, which is at pages 20 and 21 of the writ petition. Addressed to the secretary, addressed to the concerned authority of the West Bengal Board of Primary Education. So, learned advocate representing the petitioner submits that main ground of seeking transfer from present school is her ailments. Stop. It is submitted that petitioner is suffering from gynecological disorder. Stop. It is further submitted that though prayer is made for transfer on the ground of for transfer based on offline application. dated 12 September 2023. But the case of the petition is fortified by the order of the order of a coordinate bench dated 8 July 2024, passed on a writ petition being WPA 17183 of 2023. Within bracket Tamanna Begum versus State of West Bengal. Stop. In support of prayer for transfer of the petitioner, amended Rule 3 as contained in notification dated 13th September 2021, whereby amendment was carried out to West Bengal primary education within bracket transfer of teachers including head teacher close bracket rules 2002 is relied upon, which confers right upon a primary teacher to make application for transfer on special grounds as delineated under amended Rule 3. Stop. Next paragraph. Mr. Ghosh, learned advocate representing West Bengal Board of Primary Education, submits that transfer application made under Rule 3 within bracket small a as contained in notification dated 13 September 2021 needs to be considered based on provisions as contemplated under Rule 6 of the West Bengal primary education within bracket transfer of teachers including head teacher close bracket rules 2002, wherein an embargo has been imposed to the extent that a teacher is not eligible to be to apply for transfer for a period of 5 years from the date of transfer. Is it a case of transfer after 5 years or appointment?
Appointment.
From the date of transfer. That is not applicable. Mr. Ghosh.
It is for transfer.
It is for transfer.
Yes, so far as
Transfer, yes.
concerned, the rule is at Rule 4, which speaks about 2 years of continuous service.
So that has been done.
So that has been done. So I'm sorry, that is not applicable.
Mr. Bolo, এটা লিখে লাভ নেই, রেকর্ড করে দিবি। Last embargo has been imposed to be explained that a teacher is not eligible to apply for transfer for a period of 5 years from the date of transfer. ঠিক আছে, stop. According to the petitioner, according to the board, since 5 years has not complete, since 5 years is not complete from the date of initial appointment of the petitioner, she is not eligible to be transferred. Next paragraph. Having considered the respective submissions made on behalf of the parties and taking note of the relevant provisions relating to transfer, this court finds that bar as contemplated under Rule 6 of 2002 rules, 2002 transfer rules or transfer rules of 2002, as it has been provided under Sub-Rule 1, is not applicable in case of the petitioner, since petitioner has completed since is not applicable in case of the petitioner. Since
I have
after
completed, my lord,
appointment-
more than 3 years.
after initial appointment in the post of assistant teacher, it is, petitioner has been transferred, petitioner has not been transferred to other primary school. Stop. It is a case where after initial appointment of the petitioner, for the first time, she is seeking transfer on medical ground. Stop. Next paragraph. Since a case has been made out based on transfer application that petitioner is suffering from gynecological disorder, court directs Secretary, West Bengal Board of Primary Education, being respondent number 2, to decide transfer application of the petitioner dated by 12 September 2023 by 4 weeks.
4 weeks.
By 4 weeks from the date of communication of this order, and the decision to be communicated to the petitioner by 1 week thereafter.
Yes, sir.
Stop. Petitioner, stop. While taking decision, respondent number 2 shall follow the decision of the coordinate bench passed in Tamanna Begum Supra. Next paragraph. Offline transfer application of the petitioner is directed to be considered by the respondent number 2 under special circumstances, since a case has been made out that petitioner is suffering from ailments. Next paragraph. The writ petition stands disposed of. There shall be no arrest to cost or danger of sympathy.
I'm extremely grateful.
Has been brought by way of an amendment. Milord, it was in my mind, but I could not point out.
There was a subsequent amendment.
Subsequent, the same amendment. It says 5 years of continuous service in case of single transfer.
Where in the file the doctor?
Well, I'm sorry, Milord. It was in my mind, but I could not
আগে
point
ফাইলটা
out.
তো দিন।
আছে তো, ওই যে online. Milord, page 37, Milord, the amendment notification. Milord, the last clause of page 37, clause 2. Rule 4, where earlier it was 2 years, Milord, it has been completed minimum 5 years of continuous service.
In this case, 5 years is not complete.
No. 21 is the initial appointment, 1 year probation. So 22, if we Milord, take it as deemed confirmation after 1 year of probation, still Milord, the 5 years is not completed. And initial appointment is Milord on 21, Milord, page 10.
Now, whether these conditions are prevalent or prevails in case of a transfer on special ground.
Any grounds, Milord, these are the initial condition, which has to be fulfilled, then comes the grounds.
My lord, subject to correction, my lord, several decision passed by the principal bench that special ground transfer 5 years embargo is no more applicable.
In terms of clause 3.
Yes.
Page 38.
Yes.
A female teacher facing serious problem in attending the school due to divorce or death of husband.
Yes.
If divorce or death takes place within 1 year of appointment, then she has to wait for 5 years.
So, but Milord, Milord, 4.
It's a special provision. Transfer on special ground. That will not apply. If it is a case of transfer application based on distance, then this can be applied.
But
otherwise, it will make no sense.
But the special grounds, Milord, give way to rule 4. That is not explicit from the rules.
If transfer takes place after appointment within a span of 6 months, so she has to wait. If not transfer, if divorce takes place, or if a divorce decree is passed 6 months after appointment.
But probably the idea of
so therefore,
grounds will be
that lady
frustrated.
teacher has to wait for 4.5 years.
But probably the idea of special grounds
That is,
will be
special
frustrated.
ground is completely different aspect.
But that is not.
But these
Suppose
rules.
a teacher is suffering from thalassemia. He has to wait for 5 years.
But that is not
Answer
explicit
is
from the
no.
rules.
Answer
That-
is no.
Yes.
It's a special ground. আচ্ছা ওই জায়গাটা একটু ঠিক করে দিতে হবে, একটু বড় তো জায়গাটা।
Representing West Bengal Board of Primary Education submits that as per application made under Rule 3A.
Just a minute.
Mr. Ghosh, you are relying on last amendment,
Yes.
Rule 3A.
13 September.
Yes.
13 September amendment.
Wait,
Yes, that
please.
I have annexed. Lordship.
As contained in the notification dated 13 September 2021 needs to be considered based on provision as contemplated under Rule 6 of the West Bengal Primary Education Transfer of Teacher.
Or based on a provision as contemplated under amended Rule 4B. This is your case.
Yes.
Amended Rule 4 within bracket B. Of the same notification of so and so rules.
Yes.
ওই 13 September 2021 notification, বুঝতে পেরেছো? Of the same notification. তারপর কি বলেছি দেখো তো?
Wherein an embargo has been imposed to the extent that a teacher is not eligible to apply for transfer for a period of 5 years from the date of appointment.
Right, 5 years.
According to the board.
Stop. Stop.
According to the board, since 5 years is not complete from the date of initial appointment, she is not eligible to be transferred.
ঠিক আছে, stop.
Having considered the respective submissions made on behalf of the parties and taking note of the relevant provisions relating to transfer, this court finds that bar as contemplated under Rule 4 of transfer rule for 2002.
No, no,
Amended rule.
absolutely. You will not having considered.
This court finds that bar as contemplated
Under Rule 4B. Small b, huh?
of the said notification.
Right, 13 December. September.
As it has been
ভ্যাকেন্সির কথা বলছে কন্টিনিউয়াস
Now, of the aforesaid notification. বাকিটা কেটে দাও। ওই পড়ো।
Aforesaid notification is not applicable in the case of the petitioner, since after initial appointment in the post of assistant.
No, in the case of the, is not applicable in the present case. Is not applicable in the present case, since this is an application which needs to be processed in terms of amended Rule 3 within bracket A. Stop. This is not a case of transfer. This is not a case of general transfer. But transfer on special ground, as delineated in Rule 3 within bracket E, as delineated in amended Rule 3 within bracket A to 3 within bracket E. হলো, তারপরে কি বলতে দেখো, তারপর সেক্রেটারিকে দিয়ে কনসিডার করতে বলুন। ওই পার্টটা হবে না, ট্রান্সফারের পার্টটা, যেটা ফ্রম দ্য ডেট অফ ট্রান্সফার 5 ইয়ার্সটা হবে না। দেখো, এটা পড়ে নাও।
It is a case where after initial appointment of the petitioner for the first time she is seeking transfer on medical ground.
না, হবে না, থাকবে না।
Since a case has been made out based on transfer application that petitioner is suffering from gynecological disorder, court directs secretary of the board.
হ্যাঁ, ঠিক আছে।
time extend here.
Yes, next.
Number 9. In item number 9, Mr. Gormon is appearing on behalf of the state respondent. He has come to court, but due to his personal difficulty, he left the court. He instructed me to pray before your lordship. Kindly fix the matter any day in the next week.
My lord, we have a certain urgency, my lord, but my lord, date before the learned trial court is tomorrow. We have challenged an order of assessment made by the district magistrate, current form, my lord, which I prima facie can show is not as per law, my lord. My lord,
Just
kindly take my my lord, this is the-
Bormon means Hirok Bormon. But he was there.
My
2
lord,
minutes
due to
there.
his personal difficulty, he on 12 just leave.
My lord, short question of law, my lord, is settled by honorable Supreme Court.
Yes, place your case.
My lord, there was an agreement for sales. Subsequently, my lord, that could not be there, so we could, the plaintiff had to file a suit for specific
Performance.
Since the agreement was
For
unstamped,
giving effect to agreement for sale.
it was unstamped agreement, my lord, so it was to be impounded. Subsequently, the learned trial court impounded the document and sent for assessment. My lord, assessment was subsequently made after a long delay, but my lord, that assessment was made on the date when it was before the collector. My lord, the date of execution is the date from which the assessment is to be made, my lord, that is under section 2(6) of the Indian Stamp Act, and that has been subsequent.
So your contention is the date when this agreement for sale was signed and executed. That is the previous date. That has to be taken care of while assessing.
Yes.
Not on the date when it was placed before the collector in terms of the order of the trial. So there will be a difference with regard to.
Now, my lord, that is the difference we have come to, my lord, challenging that. My lord, because it is a settled principle of law, my lord, in 2023, until Supreme Court has decided on.
Yes, but first place on the stamp, place your case based on the Stamp Act.
Yes, my lord.
So before that, please tell me the facts that when this agreement for sale was executed.
My lord, kindly takes case number 25, my lord. That
Yes.
is an extra P2. The date of
18th of August
2010.
2010.
Yes, sir.
18th August 2010 was the date for execution. Yes.
My lord, kindly takes page number 55. 2012, the suit was filed, my lord, and in 2000, in page number 35, 55, and
55.
it is an application for impoundment made by the plaintiff. The subsequently, my lord, orders.
Just a minute. Yes, and it was an application for impounding
That
then.
was allowed, my lord, and subsequently page 59, my lord, that is the report of the collector. Relevant is, my lord,
This is
61.
what number of the not developers. Buses, 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 63. This additional sub-register coming from ADSR.
ADS. The origin was made by the district magistrate.
Then page 60.
Page 61, my lord. 60 is the report, 61 is the query, my lord, they have generated it online, my lord. On the date that is clear, my lord, that is 37/2018. And my short challenge before.
Where is that? Where is the date?
My lord, at the second column, my lord, query date 37/2018. At 2/10/22.
30th July 2018.
My lord, section 2, subsection 6. Indian Stamp Act.
30th July 2018. Now, what was the valuation which was assessed?
My lord, it is assessed today by the collector.
4 crores 18 lakh 62,008.
Market value 4 crore 18 lakh.
Yes.
My consideration at the time of 2010 was 31 lakhs.
So you want the valuation of 2010?
That has carried the law, my lord. My lord, 10 says section 2, subsection 6 of Indian Stamp Act.
Now, where from you are getting the valuation of 2010?
My lord, they have to maintain a register, my lord, every year's valuation in respect of a property. They will have to see from that register and give it to the court based on that. My lord, I have also annexed a document of a similar property in the close by area which shows it's much less. Now,
Yes,
my lord,
Stamp
word
Act.
chargeable is defined under section 2, subsection 6, my lord. If chargeable means as applied to the
Just a
instrument.
minute. Yes, chargeable means.
Instrument executed or first executed. After the commencement of this act, chargeable under this act. And as applied to any other instrument chargeable under this law in force in India when such instrument was executed. Or several purpose executed the instrument in different times, first executed. So, my lord, the date from first executed. So, my lord, the Honorable Supreme Court.
No, there was an amendment subsequently.
By 2023, my lord, this has been interpreted.
There was an amendment after that.
Now, this is the book of 2022, my lord. With the latest amendment. Para 11 of the.
Just a minute, just a minute. I'm not in hurry in this matter. Don't be swayed. First, let me apply my mind. Judgment will come later. Let me first consider the statute and the facts of the case. Well, you deposit the enhanced rate and then subject to the decision to be taken in the writ petition that is to be adjusted later on. No. Without calling for affidavits, I will not decide this issue.
Can you look into the judgment once?
That will be considered at time of final hearing, not now, because there is an amendment. I cannot recollect. I heard similar matter in the principal bench 2-3 years back. The amendment you are not placing before this court. So therefore, I want to hear the other side. Without hearing, I will not pass any order. If you have any urgency, then deposit the entire amount and get it registered. There is no issue. If it is ultimately decided in your favor, that is to be adjusted based on Supreme Court judgment.
My lord, till then, my lord, if a stay be given, limited time, I will pay the amount before this.
No, nothing. You pay the entire stamp duty and get it registered. And ultimately, if writ petition is allowed, then it is to be adjusted along with interest if necessary.
But my lord, my situation. Yes,
No, but because that is the final order I have to pass. Without applying, hearing without hearing the ADSR.
I'm saying let this be sent back to the district magistrate for
No.
reconsideration.
It has to be decided. Not at all. Not at all. There was an amendment. So far, I remember.
I have given.
So if you have urgency, you pay the stamp duty at the present rate and register the instrument for the purpose of the suit which is pending before the civil judge senior division, and you proceed accordingly. But if ultimately your writ petition is allowed, then you will get it back.
Then kindly gives a certain time to pay that, my lord, because the date is tomorrow, my lord. Otherwise, my entire suit will be frustrated, my lord. The earlier, my lord, because of wrong advice, the petitioners have gone from to a wrong forum, my lord. And now subsequently, we have approached this court, my lord.
Today, this suit is for specific performance of contract.
My lord, tomorrow the date is for making the payment, my lord, to get the report. My lord, we had challenged it earlier, my lord, before the civil court itself. The court did not have jurisdiction, my lord, so it could not pass any order to the collector. So we have approached this court. My lord, if this today, my lord, if it is not stayed, my lord, if there is a direction to us to pay, my lord, we will pay. But my lord, a limited time be, reasonable time be given so that within that time we make the deposit.
So how much time you require to make the payment?
4 weeks.
4 weeks.
We'll make the deposit within 4 weeks, then subject to the outcome of this writ
Writ petition. That can be done.
In the meantime, if they could file.
Show me the last order of the civil court.
My lord, may I? Only in this matter, one appeal is pending before the
No,
Commission
that
of
is not
Jalpaiguri.
pending, my lord. The appeal was.
No order has been annexed to the petition.
Appeal has been preferred by whom?
By us.
By
No,
the-
my lord, we have submitted an appeal, but my lord, it is not maintainable, so it was not registered at all. That we have submitted in the appeal. That we had, as I said, my lord.
Against the order of the civil court.
No, order of the assessment.
Assessment.
But that is not the forum to challenge that. So we have, that was not at all registered.
Have you stated in your writ petition?
I pleaded in my petition. Para 14, 15, my lord.
Is there any appeal provision under
No.
the statute?
My lord, appeal is regarding to 47A. If there is any adjudication under 47A, appeal under 47B is maintained. But our is under section 40. So that is not applicable in our case, Lord, and we are vigilance. First time.
Forty-seven is for West Bengal amendment is
Yes.
concerned.
That is regarding when the undervaluation is done by the party and the register, at the time of registration.
But 47A come to which section 47A?
Yes, madam. Whereas registering officer appointed under Registration Act has while registering any instrument. That stage has not yet come. This is
Agreement or memorandum.
order under challenge is under section 40.
Section 40.
40B. Impounding made under section 35.
Just a minute. Section 40. But according to you, under which provision of section 40 is applicable in this case? 40B.
Where the my lord, I don't.
40B.
Collector's power to stamp impounded instrument.
Collector's power to stamp instruments impounded.
Yes, ma'am. It is of the opinion.
Now, first read the first proviso. Read the first, subsection 1.
Where the collector impounds any instrument under section 33 or receives any instrument that is applicable, my lord, under section
Yes.
38(1).
Or receives any instrument sent to him under section 38.
38 subsection 2. So he has received from the learned civil judge under 38(2). Not being an instrument chargeable with an instrument exceeding 10 paise.
Yes, yes.
Not being
What is your response to that? Not being an instrument chargeable with duty not exceeding 10 paisa.
My lord, ours is chargeable with more than 10. Because
Not being an instrument. Not exceeding 10 paisa.
not being an instrument chargeable with a duty not exceeding 10 paise. Our one is exceeding.
So if any instrument is within 10 paisa chargeable,
My lord, then
that then section 40 can be relied upon, unless until there is a subsequent amendment, because this is an old act of 1899.
all the amendments there, my lord, it has been compiled with the latest amendment.
So when the collector impounds any instrument under section 33 or receives any instrument, yes, it has been received, instrument sent to him under section 38, subsection 2, section 38, subsection 2, not being an instrument chargeable with duty not exceeding 10 paisa. If it would have been exceeding 10 paisa, then it is beyond 10 paisa. Not being an instrument chargeable with duty not exceeding 10 paisa.
There is double not.
Yes.
If the
Not being an instrument chargeable with duty not exceeding 10 paisa.
My lord, it is an instrument which is exceeding 10 paise.
Not being an instrument chargeable.
The two negatives make it positive. After that, my
Not
lord, it is
being
the
an
provision that the instrument is chargeable with duty and is not duly stamped. He shall require the payment of proper duty and the amount required to the same together with the penalty of rupees 5. And even the penalty of rupees 5 is not included.
Exceeding 10 paisa. Instrument chargeable with duty.
In that view also 40 B is not being complied with. My lord. The penalty of rupees 5 is to be achieved.
So your case is coming under 40A.
40 B. Not duly stamped. When A is when it is not chargeable at all.
So the payment of such instrument is chargeable with duty. It's not duly stamped. Yes, where is the order of the civil court?
My lord, the report has been, and actually that was not given to me because it is not updated in the website. my lord.
Then how this court
Tomorrow
will
is the
consider?
date, my lord, that is when
Then how this court will consider?
my lord, the date.
You have to
I am
place.
giving my lord, upon instruction, I am submitting the date tomorrow before the learned court tomorrow.
Tomorrow for what?
My lord, for making, for payment,
So payment is to be made in court.
my lord, to the registrar, my lord, the district registrar.
So unless until you see the order of the trial court, how I can pass an order?
My lord, I have annexed the order of wherein it was sent for impoundment.
Yes.
But the last order, my lord, since it could not be uploaded in the website, we have applied for certificate copy.
So you obtain the copy and place it before this
But
court to
my
consider.
lord, if today,
So you take this point that the issue is pending before the
my lord,
court.
that has been taken, but my lord, without any court's intervention, my lord, no, if there is no stay. The learned court.
What was the order passed? Have you stated in your any paragraph with regard to the last order? Show me that paragraph you have dealt with the order of last order of the trial court. Yes,
That is not.
why not? You are addressing this court on the point of urgency. Now, if this court is not in a position to appreciate the order of the, consider the order of the trial court, how this order can be passed?
My lord, my challenge is for a prima facie
Yes,
against
your,
an assessment.
your challenge is on the assessment.
Yeah.
But unless until I see the order, how I would pass an order?
I'll take that liberty, my lord, to give it on the next date by way of supplementary, my lord, but today, my lord, my urgency stands, my lord, from on oral submissions, my lord. If it
So
will
what
take-
was, according to you, what was the order passed by the trial court?
Trial court has directed me to make the payment of, so that the document be impounded as stand.
Failing which, is there any
My
default clause?
lord, then my document will not be admissible in evidence, my lord, my entire suit will be frustrated. That is the embargo laid down by the statute. My lord, now I am ready to pay the correct amount if it is adjudicated. But that has not been done, my lord. Now, when the chargeable, it is said to be done from the date of execution, my lord.
Now, if the date of query is 30th July 2018, then why you are filing this writ petition on 11th December 2024?
My lord, that's my submissions, my lord. We have, because of the wrong advice, from legal advice. He has made an application, my lord, 3 years.
If it is so urgent,
My lord,
this
I-
query was
I-
generated on 30th July 2018, and you are filing this writ petition after 2 years.
He takes my documents, I have.
No, why after 2 years? In 18, 19, 20, 21, 22, after 6 years.
My lord, kindly takes one.
Whenever I take up these issues, I find that same problem.
No, my lord,
Your bona fide would have been appreciated, Mr. Counsel,
Yes, my lord,
had there been contemporaneous steps taken by filing the writ petition.
My lord, kindly takes page number 64.
Sorry.
My lord, kindly take. My lord.
No.
My lord,
Issue.
kindly take, my lord, there was 3 years of COVID. My lord, kindly takes page number 64.
But affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. By presenting this writ petition, challenge has been thrown on determination of market value of the land in question by generating a query, by generating a query by the concerned, by generating query by the concerned respondent authority on 30th July 2018. Stop. According to the petitioner, market value of the land in question as determined by the concerned respondent authority is erroneous and inflated. Stop. Such submission is made based on definition clause as contained in section 2 within bracket 6 of the Indian Stamp Act, 1899. Stop. Next paragraph. On perusal of the query generated on 30th July 2018, determining market value of the land in question, it appears that though such determination was made far back on 30th July 2018, writ petition has been instituted precisely after 5.5 years
There was a revision before.
on 11 December 2024, questioning such market value. Stop. Next paragraph. Having considered the issue involved in this writ petition, this court finds same needs to be decided on exchange of affidavits. Stop. Let affidavit in opposition to this writ petition be filed by 2 weeks after ensuing Christmas vacation, and affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Stop. Next paragraph. Petitioner shall be at liberty to mention the matter before the next available circuit for hearing after the time fixed herein above for exchanging affidavits. Next paragraph. Land advocate for the petitioner is directed to communicate this order to the non-appearing. All respondents are represented. All are state respondents. তাহলে দরকার নেই এটা, কেটে দাও। However, pendency of this matter shall not preclude the petitioner to get the instrument within bracket agreement for sale. Get the instrument within bracket agreement for sale. To get the instrument within bracket agreement for sale registered on payment of stamp duty and necessary fees based on determination of valuation, based on current determination of valuation of the land in question. Sentence type of bullet.
However, pendency of this matter shall not preclude the petitioner to get the instrument within bracket agreement for sale registered on demand, registered on payment of stamp duty as necessary fees
And necessary fees.
based on current determination of valuation of the land in question.
Based on the.
That is also 6 years back.
The document is with the collector since.
That is also 6 years back. Today the valuation has been enhanced.
But now.
That's why I have consciously used this term current valuation.
But for that, again, it has to be.
Now, next paragraph. If ultimately, stop. Next paragraph. Next paragraph. Such payment of stamp duty for registering the instrument within bracket agreement for sale shall be without prejudice to the rights and contention of the parties in the present writ petition. Next paragraph. Point of maintainability of the writ petition on the ground of delay is kept on. Take it back. You get it registered and utilize the document as.
Within 4 weeks in that time.
Achha.
If it will be 6 weeks because 2 weeks it will be closed.
In that event, you will get some time before the court below, before the trial court.
The courts are closed till January end.
Yes, up to perhaps up to 26, 27 January. Court will be, yes.
But if till Feb 15th will make the payment, because the document has to be sent from the court to the collector, then we can make the payment. But court, it will take some
Achha,
time.
we sentence table point. Then you will get some time before the court below also tomorrow.
However, pendency of this.
না ওই যে পেমেন্ট যেখানটা বলো
Such payment.
না না ওই যে বললাম না
Suspended of
কাল
stamp duty for register.
না তার আগে দেখো একটা প্যারাগ্রাফ দিয়েছি
The petitioner shall be at liberty to mention before the
পিটিশনার shall be at liberty
to mention before the next circular.
তারপরে পড়ো
তারপরে বলুন, however pendency of this, ওটা বলুন,
হ্যাঁ।
however pendency of this matter shall not preclude the petitioner to give the instrument within bracket agreement for sale registered on payment of stamp duty and necessary fees based on current determination of valuation of the land in question.
by
By
14th February 2025
তারপরে such payment of stamp duty.
by 14th February 2025 you make the payment, get it registered and take the benefit of this document in connection with the suit for specific performance of contracts. And ultimately, if you get an order on exchange of affidavits on final hearing, that will to be adjusted. That's why I have included the clause that without prejudice to the rights and contents of the parties in the present petition. Yes.
My lord, item number 10, I am for the petitioner.
There are certain other relevant provision. A similar matter I had an occasion to hear finally, but it is 3 years back. The present Advocate General was appealing for the petition. Mr. Doctor, go through this, those provisions. Similar issue, this 2008 determination, the writ petition was pending.
My lord, item number 10, I am for the.
Yes.
My lord, I am the, my lord, assistant primary teacher, my lord, who I am seeking my lord transfer. My service length is below 5 years, admittedly below 5 years, but I am suffering by some medical issue. My transfer application.
Just a minute. একটা line নিচে add করো।
Lordship.
Just wait, just a minute.
Lordship.
The learned advocate for the petitioner shall be at liberty to communicate this order without waiting for server copy of the order. Without waiting for the server copy of the order. In view of urgency. Yes. What is the matter?
My lord, I am an assistant primary teacher. My lord, my transfer, I am seeking transfer on my self-medical ground. My transfer application is pending before the board. My lord, page 19 is my transfer application before the board. My lord, I am suffering by
offline transfer application.
Offline transfer application, my lord, gynecological
Where is your
disorder. I have
application?
stated. Page 19 is my application. 4th November 2024, and it has communicated on 6th November 2024. Duly delivered.
Which
to the
page
office
is
on
your
6th.
application?
19. 19. Yes.
Mr. Ghosh, in this, with regard to transfer of a primary teacher, there is no provision for obtaining medical report.
Yes, it is there.
Yes.
Who will obtain the medical
new amendment has detailed the procedure. Now, once an application is submitted on special grounds or a medical ground, the board will take opinion from the appropriate government facility.
In case of inter-district transfer.
Yes.
In case of transfer in the same
The
district.
DPSC will do. The
District
same
Provincial
function. This is inter.
So that if I direct the secretary of the board, then board will obtain.
Yes. They will follow the procedure.
From which medical officer board is obtaining report?
My lord, Jalpaiguri same matter where I am working.
Allow me just if the council shall take report from concerned chief medical officer
Of this writ petition,
Of not.
show me. If council shall take report from the chief medical officer.
When the board takes a decision, board calls for the entire file from the.
Council.
Concerned.
Council.
Transfer of DPSC along with all the medical reports.
So the medical report is to be obtained by the council, even in case of inter-district transfer. And those materials will be forwarded to the board for taking decision.
Someone eating.
No, yes. That cannot be relied upon unless and until it is corroborated by supporting medical documents and the report by the medical expert. What is your stand with regard to offline transfer application? Only just a minute, I am keeping this. Nowadays, appointments are made by the board of primary education. Now, why a teacher who is staying in Purbo Medinipur, East Medinipur has been appointed in North Bengal? Yes, Mr. Ghosh Chaudhary, why a teacher of East Medinipur has been appointed in North Bengal?
Because Purvo Midnapur has no vacancy, but at this point also taken by the coordinate bench,
So
sufficient
you
vacancies are there, they are
have
suppressing.
applied for an appointment in the post of a primary teacher in which district? Alipurduar?
No, it is Jalpaiguri.
Jalpaiguri. Why you have applied for?
No, not apply. I have applied my home district. This is a sensitive issue. I have applied in the home district. There is a sufficient vacancy in the home district, but they have, I don't open mouth on this matter, but they have suppressed, concealed this vacancy.
You to open your mouth.
They are concealing, they are concealing, DPSC is concerned,
no, they have
DPSC is
not said
concealing.
anything. This is a query from the court. Answer the query of the. They are saying
nothing. They have, I have papered my home district. There is a sufficient vacancy under
Yes, tell me that why you are appointed being a candidate of East Midnapur, you are appointed in Jalpaiguri. What is the reason?
My lord, reason is, there is no vacancy in Purvo Midnapur. I have offered some other district. I have offered other district.
In your application, what are those districts preferred for appointment?
My lord, they subject to correction, my lord, there is, home district, only one district subject to selected. By that home district, my Purvo Midnapur, I have selected. After counseling, there is no vacancy in the home district. Then, my lord, another offer has given that these vacancies are available in the another district.
So
I have obtained. I compelled to obtain.
Why you
I have compelled to.
Why you have accepted a vacancy which is 713 kilometers from your place of residence?
Yes. My lord, I compelled. It is a government.
When
it is
you are
a minor subject to.
When
my
you
lord,
were appointed?
2021. Yes, my lord, I have appointed in 2021.
So within a span of 5 years, you are praying for transfer.
My lord.
It's a very easy
Right.
way to be to be appointed in a to be appointed in the home district. What prevented you to take further chance?
My lord,
Or
in
being appointed
RTI
as a
application in
permanent
the
in a
home district, my lord, in Bardhaman, I can say your lordship, in Purva Bardhaman, there is an RTI application by another candidate. There are subsequently RTI reply, there are sufficient vacancy has been disclosed in the Purva Bardhaman. In another candidate, I am not. This is the practice. This is they are concealing the vacancies in the home district and compelled to stay the candidate to
Reading
the
your
other district.
offline transfer application, because I have hesitation. I am very, you
Lordship.
know very well my view.
Lordship, lordship.
So for offline transfer application, I seldom I allow offline transfer application.
Lordship,
Now,
lordship.
now on reading your offline application, it appears more than your it is not the first ground is not your ailments or your gynecological disorder. First ground that your husband is and son is residing at Purva Medipur. That cannot be that cannot be considered as a special situation.
No, special
Unless
ground,
and
but
until you are
subject to.
suffering from ailments or serious terminal diseases.
Yes, my lord, who can
Serious
subject to
terminal
condition?
or malignant disease.
Yes, my lord, who can assess this? My lord, subject to correction. My lord, who can assess? Only medical expert can assess. If I am succeeding that medical
What
test,
prevented
then
you to make
otherwise
what prevented you to make application online?
online, my lord, at that time, my lord, online when the portal is operated, my lord, at that time, my lord, I have not completed 5 years. I have not completed. Subsequently, law has changed. My lord, I have been permitted, my lord, by Justice Coordinate Bench order.
No, if it
my
is
lord, I
a
have been
case of today, your case is not, you have not completed for here. Has she completed? Today also you have not completed 5 years.
No, not 5 years. At that time, even portal is not.
Since it is a case on medical ground, 5 years is not a criteria according to you.
Criteria.
So what prevented
But my lord,
you?
portal.
What prevented you to make application for transfer on special ground within the lifetime of the portal?
My lord, portal is there is specific clause. My lord, below 5 years candidate may not able to apply.
That is
There
for
is a jam in the portal.
That is for transfer on for general on general ground. But if it
Every
is transfer
same
on special
category.
ground, suppose
There is
there
is no another window. There is no another window. There is no another window regarding the special transfer. All special ground transfer now 2016, my lord, it is not permitted for transfer. 2016 SLST, all 2060 candidate applied in the online offline mode. In secondary level also. Utsoshri portal, there is 5 years restriction to apply on.
There is no question for permitting them because
No, my lord.
selection process has
When
been
it is
satisfied.
when it was in valid position, in 2022 it was in valid position, but there is specific bar. My lord, they cannot apply it even in the portal. There is no separate window for 5 years. Only there is a specific question.
So for transfer on special ground, there was no scope to make transfer online.
So far as the portal is concerned, it is shut down since long.
That is known to. That is from 29th of September 2022.
Yes.
So that is known, but as petitioner is submitting that if it is a case of transfer on special ground, suppose on the ground of divorce, or on the since a lady teacher has lost her husband, or a medical ground application, there is no window there was no window in the portal or on the portal permitting the applicant to make application for transfer on special ground. We'll come back at 2.
My lord. My lord.
Yes, the transfer matter is.
Yes, my lord, I'm.
So your stand is that based on the, in terms of the order of this court, authorities, board is considering,
Yes, yes.
Secretary board is considering on obtaining medical report through
DPS.
district primary school councils. That can be done.
That is their internal procedure, that will be done, definitely.
So in
will be
other
done.
similar cases, since the other teachers are getting this benefit of being considered for transfer, let same order be passed.
Let some order.
I'm obliged.
Instead of
I'm
entering into the issue that why she was appointed
That-
in other district.
The-
Once he is appointed and there is a procedure, there is a provisions related to transfer, then the petitioner is entitled to get the benefit of such statutory provisions.
The lesser we go into the depth,
Yes,
the
yes.
better it is for.
Yes. Here, date of appointment is not a bar.
No.
That is
here-
beyond 5 years.
Yes. Beyond.
When petitioner was initially appointed,
This is
My
within.
lord, 20th July 2021, 20th July 2021,
within 5 years.
within 5 years.
But as your lordship.
Special transfer on special ground.
Transfer.
Where is that provision of transfer on special ground? Do you have annexed?
My lord, this petition particularly I missed, my lord. My lord, this petition, my lord, Mr. Ghosh has the rule, my lord. Mr. Ghosh
Yes,
has
yes.
the-
Handed over
Yes,
the other
placed.
rate.
Yes,
Yes,
placed.
yes, yes.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph, matter relates to transfer of the petitioner who is working as a primary teacher in a school in Jalpaiguri. Stop.
What's the DPS for that?
Petitioner made an offline application dated 4th November 2024 to the Secretary West Bengal Board of Primary Education. Secretary West Bengal Board of Primary Education being respondent number 2, seeking transfer on medical ground since petitioner is suffering from gynecological disorder. Stop. In support of such contention, reliance is placed on amended Rule 3 within bracket small a as contained in notification dated 13 September 2021, wherein it is provided that the teacher working in primary schools can apply for transfer on medical ground in case petitioner or his slash her son slash daughter slash spouse is suffering from certain ailments or certain disease as delineated in the said provision. According to the petitioner, this is not a transfer on general ground. This is not an application for transfer on general ground. Therefore, the embargo claimed by rule amended four within bracket B as contained in the aforesaid notification dated 13 September 2021 is not attracted. Next paragraph. Learned advocate representing West Bengal Board of Primary Education, state respondents and West Bengal Board of Primary Education are represented by learned advocates. Whether the council is represented? No. Are represented by learned advocates? Stop. It is submitted on behalf of West Bengal Board of Primary Education that petitioner was appointed
And on 22nd July 2021, I have joined.
Petitioner was
22nd of
appointed on 21st or 22nd July 2021.
joined.
22nd July 2021.
I have joined, yes. 22nd July 2021, I have joined.
Page 11.
2021. Therefore, 5 years, therefore period of 5 years is not complete at the time of making application for transfer on 4th November 2024, which makes the petitioner ineligible to apply for transfer. Next paragraph. However, next paragraph. On consideration of respective submissions made on behalf of the parties and taking note of the relevant provisions relating to transfer as contained in notification dated 13 September 2021, it appears that amended Rule 3.
And it is Rule 5, subject to correction.
Rule 5?
Yes, my lord. Top in Rule 5. Rule 5, sub Rule 3A. It is the amendment of Rule 5. Subject to correction, my lord. Rule
Yes,
3
you are
is
correct.
PTR.
Yes, you are correct. In Rule 5. In amended Rule 5, sub Rule 3, ওপরেও না Rule 3 যদি কোথাও বলে থাকি মনে হচ্ছে Rule 5, sub Rule 3 করবে। In amended Rule 5, sub Rule 3, কি বলছিলাম সেন্টেন্সটা?
On consideration of respective submissions made on behalf of the parties and taking note of the relevant provisions relating to transfer as contained in notification dated 13 September 2021, it appears that amended Rule 5
within bracket 3 provides transfer on special grounds which needs to be considered by the authority separately. And while taking decision on such transfer application, embargo contemplated under Rule 4 within bracket B ought not frustrate such transfer application. Stop. If application for transfer on special ground as provided under Rule 5 within bracket 3, A within bracket A to 3E within bracket, is considered on the anvil of amended Rule 4 within bracket B on applying embargo provided therein. The very purpose of extending benefit of transfer on special ground will be defeated. Next paragraph. In view of aforesaid findings, Secretary, West Bengal Board of Primary Education, being respondent number 2, is directed to decide transfer application of the petitioner dated 4th November 2024 by 4 weeks after receiving transfer application and medical report from the authority of District Primary School Council, Jalpaiguri. Stop. You have not added chairman? Yes. Chairman, stop. Chairman, Jalpaiguri District Primary School Council, being respondent number 4, is directed to obtain medical report on medical verification of the petitioner from the concerned medical officer by fortnight from the date of communication of this order. And if medical report justifies transfer of the petitioner, same shall be forwarded along with transfer application to the to respondent number 2 by 7 days thereafter. Stop. The decision to be taken by the respondent number 2 shall be communicated to the petitioner by 1 week thereafter. Next part. The writ petition stands disposed of. There shall be no notice to cost or dangerous copy. Give a copy of this rule. Yes. Otherwise, while correcting, I will find difficult. Yes. Those.
My lord, item number 11, I am for the petitioner. My lord, in the writ petition is some defect is there. But I want to cure that defect by a way of supplementary defect is, my lord, main transfer application which was forwarded.
Withdraw the writ petition file. Withdraw the writ petition
file. Pleadings, pleadings is there, but subject to correction, pleadings is there. Only that part is annexure is missing.
Which
I'm
part?
giving the my lord, transfer application before the board. That is that I have missed, but pleadings
File
is there.
supplementary, file supplementary.
Yes. Yes. That I am paying. That I am.
At the time of call, learned advocate, now during course of hearing, learned advocate representing the petitioner pressed for leave to file supplementary affidavit to bring on record certain relevant documents.
Yes.
Stop. Next paragraph. Respondents are represented by learned advocates. Stop. You are for the state and you are for the board. School name. State respondents and the West Bengal Board of Primary Education are represented by learned advocates. Next paragraph. let supplementary affidavit be filed by the petitioner by 24th December 2024 with advance copy upon the learned advocates representing the respondents. Next paragraph, list the matter before the next circuit, subject to convenience of the bench.
I am extremely. I am
উপরে the affidavit service filed on behalf of the petitioner is taken on record.
extremely. That item number 12, my lord, I am for the petitioner. My lord, petitioner, I am, my lord, I am an assistant primary teacher. My lord, I am seeking transfer on my self medical ground. My lord,
On
now on
medical
self
ground?
medical ground. Yes, self medical ground. My lord, I am working in the district of, my lord, district of Kuch Bihar. I am seeking transfer in Murshidabad. My transfer application before
Who
the
is appearing
board.
for the board? Nobody is appearing for the board. Are you appearing? No copy. Mr. Ghosh is submitting that he has not been instructed to appear
Yes.
because no copy has been forwarded to him.
Then my lord making
When
not
the service was effected upon the board.
board, my lord, it is my instruction that copy should serve. Be given Mr. Ghosh. I don't know, my lord, whether copy has given, or whether we will make it not today. But issue is same, subject to correction.
No, but there is no service upon the board.
Yes,
Two
my lord.
postal sheets from where it appears that Sub-Inspector Mekliganj and Chairman Kuch Bihar District Primary School Council.
Yes, yes.
Where is the service upon the board?
My lord, then board is missing, my lord. But my lord, subject to correction, but issue is same. My lord, I have served the copy of to Mr. Ghosh. My lord, he is appearing in the board. My lord, he is
Very
appearing.
well, I will request Mr. Ghosh to appear on behalf of the board.
Yes, yes.
Survey copy upon him, let him take
Yes,
his.
yes.
Issue. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Since West Bengal Board of Primary Education is not represented by learned advocate, Mr. Vikramaditya Ghosh, learned advocate, who usually represents West Bengal Board of Primary Education is requested to enter appearance. Mr. Vikramaditya Ghosh, learned advocate, learned advocate, who usually represents West Bengal Board of Primary Education is requested to enter appearance on behalf of the board. Stop. Let engagement of Mr. Vikramaditya Ghosh be regularized by the concerned authority of the West Bengal Board of Primary Education. Stop. Learned advocate for the petitioner is directed to serve copy of this writ petition upon Mr. upon the learned advocate representing the board in course of this day. Learned advocate for the petitioner is learned advocate for the board is directed to obtain instructions. Next paragraph, list the matter under the same heading on where is Mr. Ghosh? Tomorrow?
Yeah.
On 19th December 2024.
I'm extremely good.
I beg to appear for the petitioner. The prayer is not for the payment of admitted dues for which the petitioner has worked and has done certain electrical works at the time of the general election.
Who is appearing?
State is served. It was served on 13 December 2024.
Not today. Mr. Bormon has left due to personal difficulty in other matter. Not today, simply not today.
Okay, my lord, I apply for the petitioner. And I find the affidavit of service. There, my lord, challenging the selection of the private respondent in a bid issued by the respondent number two, the Internal Provident Fund Commissioner. The petitioner is before you.
Tender matter.
Yes. My lord, from the track report, upon the private respondents, it has been served. Union of India, the necessary party, served. The
Selected
answering
party.
respondent, my lord, who is in
Provident Fund Commissioner.
Shiliguri, the track report is inconclusive, my lord. It shows dispatched.
Next Monday come back.
My lord, I have been instructed that Mr. Bhaskar Mahasar usually appears for.
Then all matters, this cannot be done. Let me adjourn the matter till next Monday. If the service is complete, court can consider this one. Take back your affidavit service. Learned advocate representing the petitioner. The third party who has been selected in the bid.
They have been served.
They have been served.
Yes.
Learned advocate representing the petitioner. Prays for accommodation to complete service of notice upon all the respondents. Next paragraph. Hearing of this matter stands adjourned till Monday next, comma. Monday next, comma. 23rd December 2024, in order to enable the learned advocate for the petitioner to complete service of notice and file affidavit of service.
Friday.
Friday, many matters are fixed. Yes, yes.
I'll appear my lord online. I have two matters fixed in the principal and I'll go back to Kolkata. But I can appear online, my lord. And Friday again, there's supposed to be a resolution because of that.
Election resolution will be on Thursday. No, Thursday, 19. 19.
As a Friday, my lord has kept all the matter.
So you want it to be fixed on Friday?
It is convenient.
তাহলে ওটাকে Friday করে দাও তো, Friday 20th December 2020.
Great.
For that matter, how much cost is to be imposed? Pay 10,000 rupees cost with the Legal Services Authority and amend the cost title.
Assume this is the fault on my part, my duty and my part. In that event also, the petitioner should do. I leave it to your lordship as your lordship.
একটা কেসেই তো ইডিএম এর কাটে না সবকটা অনেকগুলো কিন্তু অর্ডার শুধু একটার মধ্যে দিয়েছে সবকটার কাছে
Issue. During course of hearing, learned advocate representing the petitioner submits that inadvertently, in spite of giving liberty by a coordinate bench video order dated 13th November 2024, post title of the writ petition was not amended, thereby adding Urban Development and Municipal Affairs Department, Government of West Bengal, within bracket for short, UDMA. As additional respondent. Stop. Therefore, on behalf of the petitioner, prayer is made to grant such leave which would enable the learned advocate for the petitioner to amend the post title in terms of the leave granted by the coordinate bench on 13 November 2024. Now, it is also prayed for on behalf of the petitioner that the time stipulated for taking certain steps as per order dated 13 November 2024 may be extended. Stop. Respondents are represented by learned advocates who have not made objection. Now, who have not objected to the leave as sought for today in consideration of the order passed by the coordinate bench on 13 November 2024. Next paragraph. As a last chance, leave is granted to the learned advocate representing the petitioner to amend the post title of this writ petition and add Principal Secretary, UDMA as additional respondent in course of this day. Stop. After such amendment is carried out, after such amendment of post title is carried out, copy of the amended writ petition shall be served upon the additional respondent by
Okay.
24th December 2024. Stop. Stop. The additional respondent by 6 weeks thereafter shall take a decision in respect of the permission sought for by Siliguri Jalpaiguri Development Authority and shall file a report in the form of affidavit placing the decision which will be taken in terms of this order. Stop. The aforesaid exercise shall be carried out by the additional respondent by 28 February 2025. Stop. Next paragraph, the matter shall be listed before the circuit, before the next available circuit. After 28 February 2025. Next paragraph, liberty is granted to the learned advocates representing the parties to mention for inclusion before the next available circuit. আচ্ছা প্রথমে যেটা বলেছিলাম দেখবি ইউডিএমএ বললাম যেটা ওটা একটু সেন্টেন্সটা পড়ো তো একদম প্রথমে যেখানে বললাম না আরবান কি বললাম বলো তো
During oath of hearing, any advocate representing the petition submit that inadvertently, in spite of giving reverse by coordinating with the order dated 13th November 2024, first title of the litigation was not amended, thereby adding urban development and
না thereby adding principal secretary
urban development and
ওইটাই in course of this day as a last chance you amend it.
Not I beg to for the Siliguri Jalpaiguri Development Authority.
Yes.
16 is when I file the reply. We have report filed, we have to file the reply.
15, 16 is similar matter.
16 is not like 15. There is no leave granted. This is different.
This is different.
Yes,
But whether
issue is same.
but
whether leave has not been
whether
granted.
the issue involved in WPA 954 of 2024.
Yes, that's the same. But
2024 unless
Same,
and
same
the
issue.
issue involved in WPA 954 of 2024 is decided, other issues can be decided because all the matters should be decided in one go.
As you will not see, because some of the matters,
Because that is the lead matter. 15 is the lead matter where principal secretary UDMA has been directed to be added as a party, where principal secretary was directed to take a decision based on the proposal forwarded by the SJDA. Now, what is their decision? They would disclose it by filing a report. Based on this report, court will express its view. So unless and until this exercise is carried out, how the next matters can be decided?
Right, Lord.
That's why this matter is fixed at the top.
That's item 50. My lord said passes the order. So other matters are
to be heard along with this matter.
Identical, but some of the matters where my lord the SJDA filed the report, where from the UDMA has to be made the party. With some other matters is paid, there is also.
No.
the
If
report has not
in a
been-
single matter, if any stand is taken by UDMA, principal secretary, by filing a report, that will cover similar other matters.
Exactly, Lord.
Only may I know.
Uh,
These matters.
next matter call for
SJDA actually, SJDA published a list. Their allotment has been given.
Nothing will be done unless until you take steps. This is for your latches. Today the matter is, the hearing of this matter is deferred.
Other matters have not been given the leave, my lord. That's
Did.
Lord, in all the matters, similar leave is given.
All the writ petitions. No, the Horigopal Das, right? 954.
Horigopal Haldar.
Horigopal Haldar, just a minute. Horigopal Haldar, I have passed order just now.
Yes, ma'am.
শোনো এইটা বাদ দিয়ে এই ফার্স্ট ম্যাটারটা ফার্স্ট দেখবে এই কস্টেলটা দেখবে সবকটা ম্যাটার সেট আউট করা আছে। দেখে নাও, এদিকে দেখো, আমার মুখের দিকে না তাকিয়ে। হ্যাঁ, এটা বাদ দাও, এটাই তুমি অর্ডারটা যেটা ডিকটেশন নিলে, এটা হচ্ছে ফার্স্ট ম্যাটার 954। ঠিক আছে, এরপর থেকে 955 থেকে 9 সিরিয়ালি নেই তো।
9-5. Item number 45.
May I indicate, my item 15, 17, 18, 19, 20, 29, 30, 32 and 37 are where the order has already been passed.
কাজ
What
করো,
I did.
ডিকটেশন নিয়ে নাও, ছেড়ে দাও। হ্যাঁ, ডাকুন আইটেম নাম্বার 16টা ডাকুন তো। আইটেম নাম্বার 16 টু আইটেম নাম্বার 16 to
45.
45.
Yes, my lord.
Yes, Lordship, 45 should also be tagged with this.
No, item number 16 to 44.
Not 44, 45 is also same matter, Lordship.
45 is also.
So item number 16 to 45, 45 ডাকুন, action.
16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 27, 28, 29, 30, 31, 34, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45.
From the submission made, এটা 16 এ শুরু করবে, বুঝলে? 16 এ আলাদা আলাদা করে প্রত্যেকটাই করে দেবে। From the submission made on behalf of the parties, this court finds that that identical issue now this court finds this court finds that the issue involved in this writ petition is similar to the issue involved in writ petition being WPA 954 of 2024 within bracket Horigopal Haldar versus State of West Bengal and others. Stop. In the writ petition being WPA 954 of 2024, court has passed order today. Stop. Now, order today, stop thereby directing the learned advocate representing the petitioner in that writ petition to take certain steps. And hearing of that writ petition is adjourned till 28 February 2025. Next paragraph. Let this writ petition be heard along with WPA 954 of 2024 being analogous matter. এবার এই অর্ডারটা আপ টু 45 অবধি করে দেবে। হ্যাঁ, উইথ করেও করবে না, আলাদা আলাদা করে করবে, প্রত্যেকটাতে আলাদা একটা যেমন আলাদা আলাদা রিট পিটিশন যেটা ম্যাপের করছে, প্রত্যেকটাতে এক অর্ডার। শুধু এই রিট পিটিশন নাম্বারটা চেঞ্জ হতে থাকবে, যেটা এখানে কস্টেডেলের যে রিট পিটিশনটা সেটা চেঞ্জ, 954টা যা আছে তাই সেম অর্ডার। 16 থেকে অর্ডারটা সেম হবে, কিন্তু সেপারেটলি প্রত্যেকটা রিট পিটিশনে ট্রান্সক্রিপশনটা হবে। বুঝতে পেরেছো? কন্টেন্টস অফ দ্য অর্ডার রিমেন সেম। তুমি একবার পড়ো, আমি শুনিনি।
From the submissions made on behalf of the party, this court finds that the issue involved in this writ petition is similar to the issue involved in writ petition being WPA 954 of 2014. Within the Horigopal
954 of 2024.
Haldar versus State of West Bengal and other bracket close in the writ petition being WPA 954 of 2014 was 2018. The court has passed order today, thereby directing the learned advocate representing the petitioner in the petition to take certain steps and hearing of that petition is adjourned until 28 February 2025. Let's stop there. Let this petition be heard and move WPA 9.4 of 2024 being an another matter. It is 16 error.
বিলটা এস করলো এস অ্যানালগাস
It is 16 error.
এটা হলো 16 এবার সেম অর্ডার 17 18 19 করে আমরা করতে থাকবে আপ টু 45 আপ টু 45
Yes, Lordship, 45.
Document manner up to 45, all have been given leave to add manner. Not here and now.
you have to take steps in item number only in
As
item number 15
Mine.
that is the lead matter
Mine.
whatever decision that will be taken in item number 15 that will
Will
cover
cover-
other matters clear
Grateful, Lordship.
Here and now, manner the addition to be made, manner.
immediately
Mine.
as a last chance I have said
Today itself.
Deeply obliged.
yes who is appearing in item number 46 nobody issue at the time of call no one appears for the petitioner and no accommodation is prayed for next paragraph it appears a coordinate bench on 24th September 2024 adjourned hearing of this matter and directed to be listed in the next circuit. Next paragraph. It appears petitioner has lost interest. Next paragraph. Writ petition stands dismissed for default, urgent xerox certificate copy. Next. এগুলো কি নতুন ঢুকেছে না আগেই ছিল না আগে ছিল হ্যাঁ উপরে সেগুলো এগুলো নয় সেগুলো আচ্ছা এসো 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 ওই আগের অর্ডারটাই হবে পরও আমি চেঞ্জ করে দেবো at the time of call no one appears ঠিক আছে
Coordinate bench on
A coordinate bench.
coordinate bench on 24th.
না এটা 13 November 2024 directed the matter to be listed before the next available circuit stop. However, from the said order dated 13 November 2024, it appears no one appeared for the petitioner. Next paragraph. It appears petitioner has lost interest. Next paragraph. Writ petition stands dismissed for default, urgent xerox certificate copy. Next. আলাদা আলাদা
Petition numberটা
রাইট রাইট হ্যাঁ শুধু কস্ট টাইটেলটা চেঞ্জ হবে
আর অনুরোধটা আলাদা সেপারেট তাহলে অতগুলো ফাইলই আপনার চেম্বারে
Now, where is the report of the GTA as directed by the coordinate bench on 14 November 2024? Where is Supriya Singh? Serve notice upon her. This matter will retain its position. She is regular in our court, in this court. So, inform her. Not today. Area pension on conversion from CPF to GPF. So let it appear in the month before the circuit in the month of February. Yes, I know. So not before February. In principal bench also matters are fixed in February. Issue. As prayed for on behalf of the petitioner, hearing of this matter stands adjourned. List the matter. Before the circuit commencing from 10th February 2025. Subject to convenience of the bench. February 10, 2025 বললাম তো, subject to convenience of the bench. Yes. You are advocate on record. আচ্ছা ওই অর্ডারটা একবার ইস্যু তো একবার ওটা দেখে নি বড় তো
Platform on behalf of the petitioner, hearing of this matter stands adjourned. Release the matter before the circuit commencing from 10 February 2022, subject to convenience of the bench.
10th February 2025, subject to convenience of the bench. Next paragraph. It needs to be recorded herein that a learned advocate representing the petitioner submits that the appeal preferred by the state respondents against an order passed by a coordinated bench covering the issue involved in this writ petition is fixed for hearing by the Honorable Division Bench on is fixed for hearing in the month of January 2025. Our sentence পড়ো তো।
It needs to be recorded herein that learned advocate appealing for the representing the petition submits that the appeal preferred by the state respondents against an order passed by a coordinate bench covering the issue involved in this petition is fixed for hearing by the Honorable Division Bench in the month of January 2025.
Same order in item number 50. Same order. এই শুভেন্দু দাঁড়াবে, এখন যাবে না। হ্যাঁ 52 দেখি। Same issue, same order. Who is for the state? You are for the state. Same order. First, you have obtained revised pension payment order. Now, interest on arrear pension. First, conversion from CPF to GPF from the date of refund. Then, after issuance of the pension payment order in terms of 13 June 2016, 13 June 2014 notification, you filed a writ petition for payment of pension from the date following the date of retirement till the date of refund. That has been allowed by issuing pension payment order on 26 June 2024. Now you want interest on arrear. Same order. In all matters, revised pension payment order has been issued, releasing arrear pension from the date following the date of retirement till the date of refund. Same order. Same order. Same order.
Great. I'm good.
Same order.
Diplomacy.
59.
I represent the state, Mr. Member.
Same order.
Great. I'm for the state.
State.
I paid for benefit of over 2009.
Revised pension.
Yes.
Interest on revised.
No interest. I am retired from the, I am the postal staff and I retired from the, retired.
What about 60? What about 61?
Interest.
Same. 61 টাকা ডেকে নাও তো, ডেকে নিন তো।
I'm for the state.
I will hear 60. Wait.
I'm for the state.
শুভেন্দু এটা নিয়ে চলে যাও, তারপর ওটা নিন। Same order. 61. Then you place 60. এই ঠিক আছে, তুমি চলুন। অমিতকে সিমিলার অর্ডার না অনেক বলবো 19 থেকে 45। হ্যাঁ, দুজনে করলে সময় লাগবে, তাহলে বলে তো কস্ট আইডেন্টিটা সব আলাদা আলাদা করে করতে হবে।
করছিলাম বসে
ও তুমি এটা নিয়ে নাও, ও ততক্ষণ করুক, ওটা করলে সময় ওর একার অনেক সময় লাগবে।
করতে যাচ্ছি, বসেছি
একটু বসো, এটা হয়ে যাবে। Yes, yes, yes. Yes, place your case.
Petitioner is a DO of a Panchayat department under Calcutta block development Panchayat. And he retired from service 30th October 2016.
30th October 2016. Peon.
DO.
Group D.
The PPO was issued on 25 October 2016.
Where is the PPO?
Page 15.
Yes.
The same PPO, the October 2019, I have get the benefit.
So you are sanctioned retiral benefits in terms of which ROPA?
October 2019.
19.
2009.
9. So you want enhancement of your benefits in term or division of your benefits in terms of ROPA 2019.
29.
So why this has not been granted to you?
As per page 16.
You retired on 30th October 2016. So during your tenure as Group D employee of a Gram Panchayat, you got the benefit under ROPA 9. The ROPA 2019 came into existence from which date? Force.
2020, but effect from
Yes, came into force with effect from 14th of February 2020. But from with effect from which date?
with effect from 1st January 2020.
1st January 2020. So if it is from 1st January 2020, then you are not eligible because you retired prior to that.
You indicated that the petitioner is eligible because who retired after 2016, 1st January 2016, in this that may applicable. Kindly come to the GO below.
Yes.
Page 16 below.
3rd July 2020. Revision of pension. page 16.
Additional pension, last one.
Just under clause Roman 5. Just
First January 2016.
So it's a notional benefit you are entitled to get from 1st January 2016 to 31st December, and actual benefit from 1st January 2020. So actual benefit has not been given to you.
And device.
Who is the appropriate authority? District Panchayat and Rural Development Officer or BDO?
BDO is the appointing authority. I made the application BDO. BDO make the papers and forward it to the DGPP for granting revised pension in favor of the petitioner.
Let the representation be considered.
So whether the BDO will consider it, your entitlement. So very well, let me dispose it of directing the BDO to take decision based on this clause 5 at page 16 of the writ petition. Have you made any prayer to the BDO? Similarly circumstanced other candidates have obtained
Yes.
benefit.
This is also
Where is your representation?
page 20.
Issue. Affidavit of service. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph, learned advocate representing the petitioner submits that petitioner was a Group D employee of Falakata, which Gram Panchayat? Group D employee of a Gram Panchayat under Block Development Officer Falakata Block, District Alipurduar, being respondent number 3. Stop. Petitioner retired on superannuation on 30th October 2016, and pension payment order was issued on 25th October 2016, releasing benefits including retiral benefits, releasing retiral benefits including pension. Stop. Grievance of the petitioner is he is entitled to receive, or he is entitled to get the benefit of consolidation of pension. He is entitled to get the benefit of consolidation of pension in terms of revision of pay and allowance rules 2019.
Pension along with the gratuity. Along with the gratuity. Some gratuity.
Consolidation of pension and retiral dues.
In terms of
Revision of pay and allowance rules 2019. Stop. In support of such contention, reliance is placed on a memorandum dated 3rd July 2020, issued by July 2020, issued on behalf of Department of Panchayat and Rural Development, Government of West Bengal. Stop. Under clause A, capital A, বুঝলে? Within bracket Roman 5, small Roman 5, A5. It has been provided that the pension available to the old pensioners shall be increased with effect from 1st January 2016 to 31st December 2019. Notionally, an actual effect shall be granted from 1st January 2020 following the methodology as provided in the table appended thereto. Stop. It is also submitted that a representation is made by the petitioner addressed to the respondent number 3, seeking consolidation of pension and retiral dues, which has not yet been decided. Stop. Next paragraph. State respondents are represented by learned. You are for the state. Panchayat is not. Real video is the state authority. State, not required. State respondents are represented by learned advocate who submits, since representation is pending before the respondent number 3. In the event necessary direction is passed, respondent number 3 shall consider the same in accordance with law. Next paragraph. Having considered the respective submissions made on behalf of the parties and taking note of the provision as contained in clause capital A within bracket small Roman 5 as provided in memorandum dated 3rd July 2020. Respondent number 3 is directed to take decision on the representation of the petitioner dated 2nd October 2024, seeking consolidation of pension and retiral dues in terms of ROPA 2019, by 8 weeks from the date of communication of this order, after granting opportunity of hearing to the petitioner or his representative. Stop. A reasoned decision shall be passed by the respondent number 3, and same shall be communicated to the petitioner by 2 weeks thereafter. উপরে দেখো ডিসপোজালটা বললাম লাস্ট সেন্টেন্সে ডবল হয়ে যাবে। আচ্ছা, the writ petition stands disposed of, urgent xerox upload করুন। There is no 46, yes. No, sorry. No. হ্যাঁ কালকে কি দিতে বলছেন বলুন তো? আমরা ফাইল না আমরা কি করবো? না হিয়ারিং ম্যাটার কিছু দিয়ে দেবেন বলছেন? আর একটা সেই টু বি মেনশনটা অনেকগুলো ম্যাটার আমাকে পাঠানো হয়েছিল, সেটা ওগুলো সামনে দিয়ে দিন তো। ফাইলও হচ্ছে না নাকি? কেন সে বছরের চেয়ে অন্যবারে তো মামলা নিয়ে বেরিয়ে যাওয়া হচ্ছে। আচ্ছা, ফাইলিংটা একদম অন্যবারে কিন্তু মামলা নিয়ে শেষ করা যায় না, এবারে